instructions. I'm sure counsel has as well. This morning I did email counsel the updated ones based off what the state abandoning that second aggravating factor regarding engaged in the commission of sexual battery at the time. So that one's been deleted. The state also brought up issues regarding the language contemporaneously versus previously that I said in the email that we can discuss today. I do have the verdict forms ready. The final instructions were also sent out, including all of the mitigating circumstances the defense provided in that pleading on Friday, which I reviewed. Some of them seem to overlap with one another to some extent, but to be as fair as possible, I just listed them as the defense provided them in their pleading. I did not merge any. I didn't delete any out if they were duplicates or overlapping. I was not going to take that approach right now. I wanted to put them on the instructions, and then we could talk about them at a later time, which is going to be today, obviously. Anything from the state's perspective before we dig in?
On just any matter, Your Honor, is there a couple things?
Go for it.
Yes, sir. First, Your Honor, regarding the defense's presentation, we left here Friday understanding that they had court, and we certainly agree, required the defense with respect to who else he wanted to call. I think the representation was made. There were 2 or 3 folks in the York state put on the record who would not have an objection to working all those accommodations. Over the weekend, we have been provided 8 witnesses in New York that they would like to call. You get that on Saturday afternoon, one of which is Johnathan Quiles, so we know about him, and the other 7, obviously, I'm sure came. We have asked the defense, because it's been represented, I think on the record, but asked them to do that today, for sure an email. They were only calling those additional 8 state the relation to the defendant, they support him and love him, and who they are with respect to their name and relationship with the defendant. That's a lot of folks, Judge, for us to get. We have represented back over the weekend that the state has thrown out a different procedure. If they agree to this, we won't lodge an objection that this is all cumulative. Recognizing why, it is late notice. I'm not blaming the defense for that. It's the way it's unfolded. However,
I mean, when you say way it unfolded, what do you mean by that?
well, Friday, the court required, it sounded as the counsel I know, these are witnesses from New York that he felt like couldn't testify because they couldn't afford or didn't have the ability to fly down here. So we put on the record, the state did that. We would agree whatever method the court's done that. The court has been over backwards in making sure those 2 or 3 folks can testify. Well, now there's 8. We have asked if they would call 1 or 2 of those, state who's present, because apparently they're all together.
No, they're not.
Okay, then I stand corrected. But state who would make the same representation 8 times, putting their relation in the names on the record. That accomplishes 1, all of their names being represented during the presentation. But nonetheless, if the court does allow them to put 8 folks on Zoom, again, I'm not blaming the defense, but we've not had a chance to speak to them or propose them, obviously. We would ask that, first we would just put an objection on the record, cumulative, based on what they're telling us. Now, obviously, there's some different things that obviously can be overcome. Just for purposes of the record, I just want to put all on the record as to that issue. That's where we are with respect to this folks. Second, Your Honor, I just want to put on the record, I know we had a little bit of email communication over the weekend. The state of Florida is abandoning the aggravating factor. We engage in the commission of aggravating factor. Vessel visit on the record Friday, the one about being engaged in the commission of sexual battery. We're doing that because we believe the aggravating factor, the first one, the
time out. Let me make sure I get this right.
Yes, sir.
So, HAC, aggravating factor number 3, this only applies count 1, correct?
Yes, sir. Yes, sir, that's correct.
If I'm telling the jury, here's all the aggravating factors alleged by the state. Then I'm also telling them, following aggravating factors apply to counts 1 and 2 unless otherwise noted.
That's correct.
So, for example, HAC would be the first one where I'd say, tell them first degree murder was especially heinous, atrocious, or cruel. This only applies to count 1. That's what I'll tell the jury. The verdict form will, of course, reflect that. So give me a second here.
Absolutely.
So, on count 2 verdict form, I'm taking out the heinous, atrocious, or cruel. Correct?
The state agrees, yes, sir.
Okay, so you can go, continue.
Yes, sir. And then, so just for the record, so the first aggravating factor, the previously convicted of another felony involving the use of threat of violence of a person or arguments to both. The second one, the committed for the purpose of avoiding or preventing a lawful arrest, we're going to argue as to both. As we just said, HAC will be only as to count 1. The fourth, TCP, full calculated and premeditated aggravating factor, we're going to be arguing for both. And then have intentions to kill both. As the fifth one, the victim of the capital felony was a person less than 12. We are only arguing that for the second count, obviously, the unborn child. And lastly, we were arguing for both capital felony that was committed to someone who's particularly vulnerable and is in the position of familial or custodial authority over the victim. We can argue that as to both. So ultimately, in sum, Your Honor, the third HAC and the fifth victim under 12 only apply to one respective victim. HAC only to the IS and victim under 12 only to the unborn child.
So, in total, it looks like there's going to be 5 aggravating factors alleged as to each victim.
That's correct.
Okay.
There's 6 total, but yes, there are 5 as to each. That is absolutely correct.
So, the last one being vulnerable due to familiar or custodial relationship. As of Friday, you weren't sure that was going to both counts. Now the state is alleging them for both counts.
We have thought about it, Your Honor. Factually, witness believe it's all through the wire. That was his child. So when he's caring for him, he's in his home. Also, our argument will be he's also custodial authority over his unborn child, as he thought. So yes, sir.
Okay. So in the final instructions, there's no need for me to tell the jury anything about emerging aggravating factors, correct?
That's why yes, sir. We are not asking for none of these that are left merge. There's no need to now define felony murder or anything of that nature. So yes, sir, we believe it simplifies things, and the court has that correct.
Anything else you wanted to address?
A moment. I think the court wanted to talk about contemporaneous versus previous language.
Yeah. The reason why I included the contemporaneous language is that in instruction 7.10, I'm reading straight from it. Defendant was previously, and then in brackets, or contemporaneously convicted of another capital felony, a felony involving the use or threat of the use of violence to another person. In this case, he was contemporaneously convicted of the first-degree murder. It's not a prior sexual battery conviction that the state's relying upon. That's why I use that language. I understand how, if it's previous, it's certainly similar to the first aggravating factor under the statute regarding the prior conviction.
Yes, sir.
And so that's why I put contemporaneously, because it's provided in the standard instructions.
Yes, sir. Our only concern was that the actual statute itself doesn't say contemporaneously. However,
well, as of today, he's been previously convicted of it now.
Yes, and that was going to be our argument that you convicted him Friday of those other 2 counts. So if the court wants to give that, I would
Hold on a second. So you want previously?
The state would ask to do previously or contemporaneously, so long as the defendant agrees and does not object.
Defense, give a position. The statute says previously. I'd rather stick to what the statute says. I'm not sure why the standard instruction includes language the statute does not include.
Well, and I was going to stick with the statute, Judge.
Okay. I'll just put was previously.
And would the court make sure the defendant himself agrees to that?
Agrees to the language of the statute?
Yes, sir, because of the discussion we just put on the record regarding the alternative, he's not requesting the same. If he does, we would say the previously or contemporaneously, but if he's fine with or previously, the state is obviously with.
It's a bit of a legal issue. I'm not sure he's going to have the legal knowledge to understand that.
That's.
Or understand the distinction of the statute.
He's fine with leaving it with just previously.
State agrees.
I'm changing all the instructions and the verdict forms. But your argument is going to be that the prior conviction is the sexual battery.
Well, no, sir. Our argument is as to count one, they found him guilty of counts 2 and 3. So counts 2 and 3 sort of play into count 1.
Understood.
And then count 2, we're going to argue 1 and 3.
So you can argue the other murder as a prior felony under that aggravating factor?
Yes, sir, because they convicted him on Friday.
Okay. Makes you wonder why you wanted to proceed. Well, never mind. I'm not going to get into that. Okay. I made any changes on the verdict forms and the standard instructions for both preliminary instructions and charging instructions, which I will send a copy to everyone as well once we finalize all this. I need to change the language for the last aggravating factor. What I can do is that the victim's name is going to be actually in the instruction regarding vulnerability due to their familiar custodial authority. What I may do is just have it language for IS and say this applies to count 1, and then have another paragraph that says that for the unborn child that this applies to count 2.
Yes, sir. State agrees.
Judge, just for purposes of the record, I understand how the state is proceeding on the last aggravator, the familial. We would object to it as Mr. Quiles was not in a familial position over IS at the time. He's not her father. He's not a caretaker or caregiver. I mean, she did go over to his residence, but he was not in a familial capacity to her.
Well, the statute says familiar or custodial.
Just over defense's objection, Your Honor.
Understood. He was also found guilty of sexual battery in a familiar or custodial relationship as well by a jury, so the jury can make that determination if they believe it's familiar or custodial or not for either IS in count 1 or the unborn child of IS in count 2. So I'll leave it up to the jury, but if you need to make a motion at some other time during the pendency of phase 2, obviously you're more than welcome to make those motions or arguments throughout the pendency of the second phase.
Yes, sir, Your Honor. We just, for purposes of the record, we wanted the objection noted for.
Okay, and it hasn't gone to the jury yet, too, so.
Right.
Other than the defense witnesses, any other issues from the state's perspective?
Yes, sir, there's one more, just for the record, maybe the court would decide to inquire. The defense did let us inquire Dr. Rohr, R-O-H-R-E-R, on Friday. We spent 35 minutes with her in this very courtroom and sort of gleaned from her what she would be testifying about. We were not asking for any rebuttal with respect to what we anticipate to say. However, talking with her, she did. I asked her to sort of, in her testing, pull out some personality traits that she found in the defendant. She used terms like egotistical, self-centered, narcissistic, and some things that I will listen across. I just want to make sure that I'm sure the defense made their own decision about whether to call her. I believe they are. So at the moment that they do, I just want to make sure the record's clear. We are listening to that. And that.
Is this information that was in her report or things that you gleaned from her?
Yes, sir.
Well, hold on a second. Let me finish the question. Just for the transcript. Are these issues or information that was gleaned in her written report, or things that you got from her via deposition or through interview of her?
What we were asking her to define terms in her report and asking her and sort of summarizing her opinion that she wrote in her report, what types of conclusions that she determined regarding the personality traits. She started offering those. So while she doesn't write every single one of those, I think it's clear in the report, what does eventually define antisocial personality disorder. As we were delving into that, that's when she started describing what personality testing showed. So our position is across. We're going to elicit that. Just want to make sure that the opinion themselves is one, soliciting that. Two, the fact that they're calling it, they probably made their own decision. But that's just something we want to talk about.
Okay,
We are aware, Judge.
understood. So nothing else from the state perspective, anything from the defense perspective?
The last thing, judges, I think the court may already know, we did, or maybe you don't, we gave them 2 victim impact statements. We are intending on calling SF and
Not the mom.
sir.
Okay, for whatever reason, I just wanted to clarify, because as of Friday, it seemed to it'd be the mom and somebody else.
Yes, sir. That's the 2. So we did send that very late last night. We apologize. It was probably around the 10 o'clock hour. We actually had a victim advocate staff member working with the family trying to get them to get those needed. We finally got those done. We sent those last night. We're told this morning there's some objections. What I've asked before they're read is to send to us or highlight for us what they want. We'll find objectionable, maybe we'll agree without the need to discuss any further. But we haven't seen that yet. To know all the defense, we harmonize over. Family worked hard on this over the weekend. And we got them late last night.
Just to be clear, Dan, we only received 1. There's only 1 on your attachment.
Were both documents in the same attachment potentially?
No, Judge.
No, 1 is clearly just SS.
So the record's clear. I'm not handing the photo. Just can't control the glimpse. One's about 2.5 pages, and the other one's from SS, double spaced, about 4 pages.
The one from SS we have, the one from,
All it takes.
we did not get that one, Judge.
Did she testify at trial?
She did not.
That's ID's mom?
Stepmom, Your Honor.
Stepmom, that's right.
Yes, sir, Your Honor.
Okay. I'm supposed to have a jury in front of us in about 20 minutes. How we looking?
Judge Weed. I'm looking through my email, and just for the record, we did receive an email from Mr. Skinner at 10:02 p.m. last night to Bob and I saying here is 1, and it attached the one that we have had a chance to review and do have some objections to. I'm looking now, I'm looking in my spam. I do not have another email from him with this one, so having just received that, Judge, I would like the chance to review that. Obviously, it's going to take longer than I think 20 minutes to line item that.
Or if that didn't go to our mistake, I will send that. Giving them a hard copy, I will go ahead and copy.
Who are the 8 people from New York you're trying to call off this list? 8 to 9, however it may be.
Yes, Judge, and just to confirm, I did speak with Paulette, who is the defendant's mother, or aunt, but in a mom type of position. She did email me this morning and let me know those who could for sure be present. As you're aware, on Friday when we found out about the Zoom, I just asked her to give me the list of people she thought would be appearing so that I could provide that to the state. I did do that, but as far as who will
Can I state something? I also want to make it clear. I didn't know it was not. I didn't know it would be an issue. I didn't know who the defense was calling in the penalty phase if the trial got that far. I know there was the witness list. I didn't really inquire beyond that. I didn't know people from out of state wanted to be present but could not be present, whether it be logistical or financial reasons. I had no knowledge of that until Friday. The state didn't object to Zoom. I made it happen with the courthouse information technology people. I didn't know it was an issue. And if it became an issue, I can't imagine the state would have objected. They didn't object Friday. Now that's why we're in the position we're in right now.
Yes, Judge, and I had no intention of making it seem as if it was the court's fault by any means.
Sure. I just wanted to make sure that was clear for the transcript, if in case it's an issue on the back end, that it was not an issue that I knew that needed to be addressed until Friday, until I inquired of Mr. Quiles.
Understood, Judge, and there may just have been some miscommunication there, because when we talked about using Zoom throughout the trial, the court had made it clear to those who had been appearing via Zoom throughout the pre-trial hearings that Zoom would not be available, and I think that's when we kind of said, okay, if Zoom is not available,
Yes.
then we move.
It was not available.
Right.
It's not available for members of the public to come watch the proceeding. Obviously, we had issues now with people on Zoom making sign language to your client. I was not going to allow Zoom to be present during the course of a trial. It's a public courtroom. People can come watch trial as much as they want. They can probably go watch a live stream if they want. But I was not going to have Zoom be present for members of the public to come watch the trial. That's not appropriate. And nor has the Supreme Court ever said that's appropriate. They've allowed it for pretrial proceedings, attorneys to appear. Never has it been made available. And I think I've been very kind's not the right word, but I've allowed Zoom at a lot of proceedings, particularly in this case, for victim's family too, defendant's family to come present when they normally would not be able to attend certain proceedings, and I understand that. But when it comes to evidentiary hearings, when I got a job to do for a trial, Zoom was never going to be on the table. Now, for people to attend a trial to testify, that's a whole different analysis, if you ask me. But understood. But nonetheless, who are the eight or nine people you want to call from New York?
Yes, Judge. So I sent the list to the clerk a little earlier. From that list, my understanding is that today it will be Paulette Burette who will be testifying in person, KB, Kenneth Berry on that list, in person, Curtis Hale in person, Ishana Pugh in person, and Karen Gaines in person. Or her name might be Karen Gaines McMillan, if I'm not mistaken.
Okay.
And then on Zoom, Judge, they have tried to limit those to just 3 of the 8 that were listed to accommodate what the state's request was, as far as not wanting more than that.
I mean, I haven't ruled on that. They've made an objection. I don't know what these people are going to say. You guys work it out on your own end of who you want to call and not call. That's fine. But I have not. I've chosen not to get involved on purpose because I don't know what these people are going to say.
Understood, Judge. As far as what 3 that would be via Zoom at the moment, if there's no objection, would be Vanessa Brassedy. I may be saying that wrong, but it is spelled Bracetti. I'm sorry. Let me get the exact spelling for the record. I think, or was it provided to you? Okay, great. Destiny Quiles and Joseph Quiles.
And those 3 are in New York, I'm assuming.
Those 3 are all in New York, Judge, and they would be testifying on Zoom individually.
And they're available this afternoon?
They're available whenever we need them, Judge. I did tell them to make themselves available anytime after 10. I didn't give them an exact time. I said I would let them know as we progressed exactly what time they would need to be on. I did also let them know that they would not be sitting on Zoom all day, that we would open it when it was time for their testimony, so they're aware of that. And there was one other thing, Judge.
And Dr. Rohr's the only one not on this list, I'm assuming.
And Dr. Rohr, I apologize.
Yeah.
The only other thing, Judge, is that they... Sure. And just for the record, the state would like us to put their relation to Mr. Quiles. So Vanessa Bracetti is a long-term family friend who's like in a sister type of, they grew up together type of situation. Destiny Quiles is a cousin. A niece. And then Joseph Quiles is his brother. And I believe they know the relation of the people who are in person because they've asked that.
Okay. And so those are the 3 you guys are calling this afternoon upon your own agreement after talking to the state about the number of people from New York?
If there is no objection from the state, we would like to call those 3 out of the 8 of the names that we provided.
You know, the state's not objecting with respect to 3 when it was just represented to us over the weekend that they were going to call 8 to say a very, very similar testimony, which we felt was cumulative. If they're only calling 3, there is no objection
And Judge, just to be clear as well, I did speak to them this weekend about having them appear in a way that they could express their support, but then not necessarily all testify to the same thing. And what they have agreed to do is to state their name, who they're speaking on behalf of, because some of them are like, I'm speaking on behalf of my sister, my mother, and so as well, who would be here and present and say the same thing that I'm saying right now. We agreed that that would be the way we would handle it instead of calling each and every one of those witnesses, just to avoid that very objection that we, of course, would not try to present duplicates of this exact same information or cumulative type of information. So as long as that's not objectionable, we would plan to proceed in that fashion. We have spoken with...
I'm sorry, my fault. Please continue.
We have spoken with Mr. Quiles about presenting these additional witnesses. He did want some of his family that lived and reside in New York to be able to appear, and so at this point in time, if there's no objection, then we would proceed in that manner.
And those are the three that, the people in New York that he mentioned 2 to 3 on Friday. Obviously, that number grew. Now it's shrunk to 3, and then those 3 are testifying on behalf of other people as well. That's to his satisfaction. That's what he wanted you guys to do.
Yes, Your Honor, I think that would satisfy. And frankly, Judge, those are the people who are available. And so I think there may have been one other person he wanted, but that person is not available to do it. So they plan to speak on behalf of the person that he planned to or asked us to get.
Okay. Mr. Quiles, can you raise your right hand? Do you swear, affirm, tell the truth, the whole truth, nothing but the truth? All right, sir. You can put your hand down. You've heard the conversation this morning regarding these witnesses, the 5 to 6 people in person or so, and that includes the expert, Dr. Rohr, and then the people on Zoom. Is that with your satisfaction and agreement?
Sir.
Okay, those are the people that you want to have testify on your behalf, and those people are going to be testifying on behalf of other people as well from your family.
Correct.
Is that what you want? And your attorneys have talked to you all about this?
Yes, sir.
They've answered all your questions?
Yes, sir.
Anything else? Anything else from the defense on this issue?
As far as the witnesses, Judge, no.
Okay. All right. Thank you, sir. So then the only outstanding issue this time is the victim impact statements for review?
Yes, sir.
Okay, so obviously I have a jury arriving here any minute. What do you want me to tell them?
Judge, as far as the victim impact statements, Mr. Davis is going to try to review and line item the one. I'm going to try to do the other right now. We're going to work as quickly as we possibly can so that we can be ready to go. If there's no objection, we'll provide that to the state. If they're okay with striking whatever we have, then we can move forward. If there's going to be some additional argument that needs to be made, then I think we should bring that to your attention after we've had a chance to look at it.
How long do you need to review everything?
We've already looked at the one, so I think he's just going to mark what we discussed already. This is like 2.5 pages, so I'm sure I can read and start marking in the next 10 minutes, 15 minutes max.
Okay. How about I'll come back out around 10 o'clock, which is what I told the jury anyways. At that point, maybe we'll have at least one statement should be, you would think, close to being completed, and then we'll see where we're at in the other one.
Yes, Judge.
I just wanted to let the jury have some idea of what we're dealing with. That way they're not sitting in a room waiting for us. Just so you guys know, my office made contact with the 4 alternates. They were told to be present. Actual conversation and verbal contact was made with all 4 of them, and they told my office that they would be here by 10 o'clock for the proceeding. So let's come back out at 10 o'clock. We'll see where we're at, and we'll go from there. I will share with you guys the preliminary instructions as well. It should be complete, and I'll be reading to the jury as is. We can deal with the final instructions and verdict forms as we get there, although I probably will go ahead and share everything with you guys. That way you have everything. The verdict form should be rather complete. It has the aggravators, the states listed. You guys can look at the final instructions. It has all the mitigators the defense is relying upon. And you can take a look at that. You weren't here when I told Mr. Davis this, Ms. Michelle, but I listed the mitigating circumstances as it was phrased in the pleading. I didn't really change anything up. Some of them seem to overlap a little bit with one another. Some of them have like the same beginning, but kind of go to different directions. So I put it as is. I didn't want to mess with anything. If you guys want to combine them or separate them out, I'll leave that up to your discretion as how you guys want to proceed in that regard. Some of them mentioned, he was 15 when he dropped out of school or something and had a child, and they kind of all talk about the same thing, but then go on a different branch off that tree. And that may be on purpose. I'm just letting you know what I did so you guys can take a look at it.
Yes, Judge.
Okay, so we'll be in recess till 10 o'clock. Let's go on the record, 19 CF 7518, State v. Johnathan Quiles. We have counsel of state defense, Mr. Quiles present. I do have all 16 members of the jury accounted for.
Sorry, Judge.
How much time do we need?
We were actually
Discussing it with the state as far as doing some of the redactions, we were going over.
Give me a time so I can let the jury know, because they're waiting on us at this point. And I think my feelings about having them wait on us is quite apparent at this point.
I think 5 minutes would accomplish what we're doing.
I was going to say between the two, give us 10.
Can you let the jury know 10:30, please? 10:30? Yes. If they want to walk around, that's fine as well. Just be back outside here that we can start at 10:30. I'll see you guys then. I have counsel of state defense, Mr. Quiles present. How are we at? How are we with the next statements?
Good news, Your Honor. We do have an agreement. And to make it simple, the state of Florida is asking to file a clean, original copy of both, one of Paula Dixon and the other of SS. And I'm, just for the record, it's Dixson is how she has it spelled in her victim impact statement. And then, Judge, we'd like to make this a court-only composite exhibit for the clerk to then file right behind it the exact same thing with the defendant's objections. One, the objections are noted in red, and on the other, the objections are noted in highlighted yellow. What we've done, Your Honor, we'd like to file both sets of these to show, if needed, at a future date, the appellate court, what was objected to, and then the state has agreed to all the requested objections by the defense. So we have taken those out by providing a copy to each respective witness, blackened out of the exact same portions that were objected to, so then the record will reflect when they testify that what they'll read will actually match what has been objected to. So at this time, I'd like to file the first clean. It's one copy of both victim impact statements with no markings, and the second will be both victim impact statements with the defense requested objection of disagreement.
So are these being filed on the docket, or are these being taken for evidentiary purposes?
Just for purposes of the record to be filed with the clerk. We're not obviously asking them to go back with the jury with all the markings on them.
So I guess my question is, are they going to be filed to where you can go on the docket screen and see these statements, or are they being filed for identification purposes only to where they're essentially part of the evidence that will go to the appellate court?
Judge, just file on the docket. Again, they're going to be reading this in open court, so we have no issues with it being filed on the docket.
Okay, so they're being filed on the docket.
Yes, sir. And then what the
Is there a better way to handle that?
Judge,
Maybe can they just be filed as for identification purposes for the appellate courts versus it being filed so there's public record on the docket now?
I have no objection to that if that's what the court requests, and there's no objection on the state.
Okay, so I can make them a court's exhibit. Obviously, if they're not my evidence, of course, but for purposes of just the evidentiary purposes, they're not filed on the public domain. They can be made as court's exhibits 1 and 2. We all know what they are. Everyone's agreeing to what they are. It's just for purposes so they can be sent to the appellate court for review at a later date if that's necessary.
Yes, sir. The state agrees.
Defense agrees to that, Judge.
Okay, so we'll mark court exhibit 1 will be the ones that they're actually reading, and then a clean copy. Then count 2 will be, or court exhibit 2 will be the ones that have objections to it. Is that how you did it?
Yes, sir.
Oh, I'm sorry. Is one court exhibit 1 is one witness, court exhibit 2 is the other witness?
No, sir.
Okay.
Court exhibit 1 is both victim impact statements, unredacted.
Okay.
So the appellate court will have that on the record, and then the second court exhibit will be both victim impact statements with the defense requested objection.
Okay, you said it better than me.
Yes, sir.
And so to get to the end on this, the parties have agreed, or the state is conceding to the objections made by the defense on everything raised off both statements, and that'll be presented to the jury.
Yes, sir.
Okay. So at this point, are we ready to proceed?
Yes, sir.
You guys have seen the plenary instructions. I'll read to the jury with the state's aggravating factors and what's applying to counts 1 and 2. That's really the only thing that's necessary for me to insert in the plenary instructions compared to the final instructions.
Judge, we just have to renew our prior objection that we had raised earlier for purposes of the appellate court, stating specifically that we do not agree with the aggravator of the familial. I believe it was number 6 was the aggravator.
Correct.
We are objecting to that, Judge.
Okay. I don't think I asked the state for any position on that. Do you want to state anything more so than what the record already has on it?
No, sir. I think the court pointed out the record it's familial or custodial, being that he's in a relationship with her as her uncle, and with his belief that was his child and the motive for the killings, we believe this, particularly the facts, and I'll get into the facts and argument later today, but with all the things that I'm too time-consuming now to go into, but with all the facts that bore out over the year and a half leading up to this, the state's position is that most certainly is a custodial relationship.
For scheduling purposes, I would probably get through openings and maybe the state's first two witnesses. The state will probably rest at that point. Probably take a lunch break then, and then I'll turn everything over to the defense, and then Zoom will be set up for you guys to use at your disposal.
Just so the court knows, our opening statement is brief. The defense has advised me that it's just 5 or 10 minutes, and the victim impact statements will be 15, 20 minutes, both reading them. So if the court wants to keep going, we're at the court's pleasure, but we will rest at that point.
After they arrest, we could probably get through Dr. Rohr before lunch.
Do I need to dismiss the jury for any motion practice after the state's case? Okay. Any reason why I can't bring the jury in?
No, Your Honor.
Defense?
They are.
All right, let's bring the jury in, please. Okay, that's fine.
Your Honor, the jurors are entering the court.
Members of the jury, welcome back. You guys may have a seat. Does everyone have their notepads? Okay. All right. Well, good morning, everybody. It's good to see everybody. Hope you had a nice weekend. We're going to go ahead and get started. I have some instructions to read to you guys before we get started. Members of the jury, the defendant has been found guilty of 2 counts of first-degree murder in a previous proceeding. The only issue before you now is to determine the appropriate penalty. The penalty for each of these crimes is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the attorneys say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence, along with the evidence that you have heard during the guilt phase of the trial, is presented to you to determine whether the state has proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors are sufficient and whether the aggravating factors outweigh any mitigating circumstances the defendant proves by the greater weight of the evidence. Finally, you will decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case are as follows. The following aggravating factors apply to both counts 1 and 2 unless otherwise noted. Johnathan Quiles was previously convicted of a felony involving the use or threat of violence to another person. The crime of sexual battery is a felony involving the use or threat of violence to another person. 2. The first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. 3. The first-degree murder was especially heinous, atrocious, or cruel. This aggravating factor only applies to count 1. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily tortious to IS. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the crime of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. The unborn child of IS was a person less than 12 years of age. That's for number 5. This only applies to count 2. Number 6. IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over IS. This applies to count 1. The unborn child of IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over the unborn child of IS. This applies to count 2. Once the state has presented evidence of the existing of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for the defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law. After the final instructions are given, the alternate jurors will be released and you will begin your deliberations. You should not form any definite or fixed opinion until you have heard all the evidence, the argument of the lawyers, and my instructions on the law. Until that time, you should not discuss this case among yourselves. Your decision must be based solely on the evidence or lack of evidence and the law. During the penalty phase, the court will take breaks and you are permitted to separate and go about your personal affairs. During these breaks, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them that you're on the jury and ask that person to stop. If that person persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during breaks, but even then you must not use your devices to find out information about the case or communicate with anyone about the case or the people and places involved. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each breaks, please double check to make sure your cell phone or device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The penalty phase must be tried by you only on the evidence presented in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, internet, any electronic device, or any other means at all to get information related to this case or the people and places involved. This implies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned or use the internet to look at maps or pictures to see any place discussed during the penalty phase. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. Do not let even the closest family members make comments to you or ask questions about the penalty phase. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about the case by using an electronic device. You must not use phones, computers, or other devices to communicate. Do not send or accept any messages related to this case or about your jury service. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, and make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence presented. Any independent investigation by a juror unfairly and improperly prevents the parties from having the opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as jail time, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence. And the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. It is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. It may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will take. When such conferences occur, they will be conducted to consume as little of your time as is necessary. We'll begin with our opening statements. And State, you have the floor.
Please support.
Yes, ma'am.
Good morning, ladies and gentlemen of the jury. The state of Florida thanks you all for your time and attention that you have given the past 2 weeks, and including the verdicts. Johnathan Quiles is now a 2-time convicted murderer and a convicted sexual batterer. Each of you know the horrendous facts that occurred in this case back in December of 2018. Each of you know why the defendant killed IS. Each of you know why the defendant killed IS's unborn child. Each of you know how the defendant killed IS and her unborn child. You all know about the ongoing sexual abuse that the defendant did of IS in the late 2017 going through 2018. Each of you did justice when you convicted the defendant beyond a reasonable doubt of premeditated murder of IS and the premeditated murder of IS's unborn child. Phase 2, though, ladies and gentlemen, is about fully holding the defendant accountable for each of his actions that led to why we are here today. State will rely on the evidence that you all heard during those 6 days in Phase 1. We will now commence Phase 2, which will be the weighing process. And Mr. Skinner discussed this during, if you can recall, 2 weeks ago during jury selection going into that second and third day. Now, the first thing that will be asked of each of you is if the state has proven beyond a reasonable doubt the alleged aggravating factor. Now, we have alleged 5 different ones for each murder. However, there are 4 in common that will be applicable to the premeditated murder of IS and her unborn child. And then there is a different one that will be applicable to IS and a different one that will be applicable to only the unborn child of IS. Now, if each of you find unanimously, beyond a reasonable doubt, that at least one of these aggravated factors we have proven, then you can move on to the second step. And that second step is where you weigh and whether the aggravating factor is proven is sufficient. If you find that the aggravated factor is then sufficient, you then will move on to the third and final step, which is whether the aggravating factor outweighs any mitigating circumstance provided by the defense, and that has been proven by the greater weight of the evidence. Now, again, as the fact finder, as the juror, you can determine if that weight is great, medium, slight, or holds no weight. That is, again, your right, your choice as a fact finder, as a juror in this case. Now, an aggravating factor, it increases the gravity of the crime or the harm to the victim beyond the harm inherent in every first-degree murder. And again, you will hear victim impact evidence. However, this is only to demonstrate the victim's uniqueness as an individual and the loss to the community of the victim's death. However, victim impact evidence must not be considered by you when weighing each and every aggravated factor that the state of Florida has alleged. The aggravating factors, I'm just going to cite a couple of points and then move on, ladies and gentlemen. The first one is that Johnathan Quiles was previously convicted of a felony involving the use or threat of violence to another person. And keep in mind, the crime of sexual battery is a use or threat of violence to another person, just like each murder is. So if you all think about it, in count 3 of the indictment, previously, because we have heard that he was convicted of sexual battery. He was convicted of 2 counts of murder. So in thinking about IS, that previous felony, because the defendant is now a convicted 2-time murderer and sexual battery, you can use that sexual battery, or you all could use the murder of the unborn child of IS. 4, when weighing whether or not the murder of IS. Then when thinking about the unborn child of IS, you can weigh that again, count 3, the sexual battery, and also you can then also weigh the murder of IS for count 2. And just thinking again about SS witnessing the incident about a year ago at that 1503 16th Street, the DNA results from March of 2018 regarding the sexual battery, and the IS was staying the night with the defendant during the weekend of July 7th, 2018, and that she was pregnant over 5 months at that time. The long drives, as we had heard evidence from you submit, that you had heard evidence involving the Trout River location and the defendant's van. And again, lastly, the defendant's statements and confession to the wire, which is state's evidence 66. Then about a year, the defendant had stated, or maybe less than a year, and it had been about a month prior to the last time the IS had sex, given the fact, too, that the sexual battery had occurred and had been occurring prior to December 19th and 20th of 2018. The next one for consideration that's alleged aggravating factor by the state of Florida. The first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Well, again, we have heard that the defendant, even with the thought we submit that it was his child, it didn't even have to be his child for the defendant to have committed murder on the unborn child of IS or of the murder of IS. In fact, in State 66, in the wire, quote, as she had gave birth to that baby, I'd been sitting right here with y'all. She was killed to avoid sexual battery charges, and the unborn child was killed to avoid sexual battery charges. Next alleged aggravating factor by the state of Florida was that the first-degree murder was especially heinous, especially atrocious, or especially cruel. So I'd like to point out, it's an or. State of Florida does not have to prove all 3 by a reasonable doubt, but we do have to prove one of those by a reasonable doubt. And Your Honor will go over what those definitions are again later today. And again, in thinking about those terms, what we heard during the evidence in Phase 1, again, the IS was 5 months pregnant between December 19th and 20th, 2018. The defendant stated that after he falsely lured her to his employment at Ace Pickup Park, that they would run away. He strangled her, but he could not stomach it. Basically as a way to kill her, so eventually shot her in the chest and the heart. And again, we had heard this from the confession of witness testimony of Johnathan Quiles, the brother. Next, the alleged aggravating factor by the state of Florida that we intend to prove beyond a reasonable doubt The first degree murder was committed in a cold, calculated, now this is an and, so we have to prove all three, premeditated manner, without any pretense of moral or legal justification. Again, in thinking about count 1 and 2, thinking about cold, we submit and recall the evidence to you all regarding what Naomi Mobley stated. After IS went missing, he slept like a baby. Also, too, in hearing from Joseph Quiles and what he had stated during his messaging with the defendant back in December of 2018, he talked about the defendant's selfishness as well. Calculated that the defendant planned the murder of IS and her unborn child for months, as we heard from Joseph Quiles during the evidence of Phase 1. Again, about the alerted to his work false pretenses. Turning off the phone location of the defendant. IS turning off her phone location data. Having IS in a remote area of Ace Pickup Park. Not having video surveillance located at that place at Ace Pickup Park. The defendant having access to vehicles, a firearm, a forklift, the knowledge of the container and how it would go weekly, getting duct tape, having bags, and then afterwards going to the gun range. The defendant knew in August, as we heard again through evidence through Phase 1, that IS was pregnant based upon those Snapchat messages in State's Evidence 63 and 64 as early as August of 2018. IS did not want an abortion. We also heard from the evidence during the case that her family members did not want her to have an abortion. Ms. Mobley had stated she found out on December 3rd, 2018. Ms. Naomi Mobley stated that the rest of the family found out on December 6, 2018 during her testimony. And we all know that the pregnancy was confirmed by Dr. Achu on December 13, 2018. The pressure was on the defendant. We also heard from Naomi Mobley regarding his actions, his nervousness, fidgety, something was bothering him, and that he knew the consequences, as stated in The Wire as well. Sitting right here with y'all, again, as she had given birth to that child. So we submit the evidence will show that we have proven cold, calculated, and premeditated. The unborn child of IS was a person less than 12 years of age. This is only applicable and alleged to count 2 involving the unborn child of IS. You've heard testimony again that she was 5 months pregnant on 12/13/18 by Dr. Achu. You have seen a picture of IS, which was State's 23, where she was pregnant. And you all have also seen State's Evidence 24, which is a picture of the sonogram that Dr. Achu performed. That, in fact, we feel comfortable that you all will find beyond a reasonable doubt that we have proven this aggravating factor that IS's unborn child was less than 12 years of age on December 19th through 20th, 2018. Lastly, IS and her unborn child of IS was particularly vulnerable because Johnathan Quiles stood in a familial or custodial authority over IS or IS's unborn child of IS. So first, in just thinking about IS, I would submit and bring your attention to count 3 of the indictment during Phase 1. One of the elements that the state of Florida had to prove beyond a reasonable doubt was in fact that Johnathan Quiles was in a familial or custodial authority over IS. You all have already found that to be beyond a reasonable doubt. You all have already heard testimony by multiple state witnesses that the defendant was in fact her uncle. IS was over the home. He would teach her how to drive, teach her how to swim, and that Naomi Quiles, the aunt, would not be there, and Miss Kim Mobley would be at work. Now, in regards to the unborn child of IS, I would submit and bring your attention to the testimony provided in the Snapchat messages and then combined with the testimony of Naomi Mobley. When the fact is, well, again, and coupled with the information that we already know, that the defendant discussed about eating and making sure that she got enough food for the baby, as we had read in those Snapchat messages, as Ms. Mobley had indicated, the defendant was doing the same thing for IS as the defendant was doing for Naomi Mobley, because she was also pregnant at the same time. So, ladies and gentlemen, at the conclusion of Phase 2, the state will have proven beyond a reasonable doubt each aggravating factor that we have alleged. We will ask you all to then find that the weight, that they are, again, substantial, and that the weight of the mitigating circumstances that the defense will provide will not outweigh each aggravating factor beyond a reasonable doubt, and will ask you all to render a vote of death. Thank you all for your time and attention.
Yes, sir. There's a microphone for you if you need one as well.
Thank you, Your Honor. Good morning, ladies and gentlemen. Again, we stand before you today. We are asking you to listen to the facts of this. And we've heard your verdict, and we are asking you to weigh the life of Johnathan Quiles. In doing this, we want you to keep in mind that Johnathan Quiles, although you have found him guilty of this act, does have certain redeeming factors. In doing this, we intend to show and bring forward several of his family members, as well as a psychologist, Dr. Jennifer Rohr. You will hear from his family that Johnathan Quiles was raised by his mother almost exclusively, as his father was not in his life. You will also, we believe the testimony you're going to hear today is that until you found him guilty, he had no prior criminal, any other criminal offenses. Johnathan Quiles was 33 at the time of this incident, of which you found him guilty of. Prior to that, he did use drugs and alcohol, mainly marijuana, but when he was a younger child, of which he was engaged in another sexual relationship at a young age, and as such, he quit school at a young age at 15. Since that time, he had 5 children. Up until his arrest, he was raising those children, taking care of all of them, and worked very hard. You're going to hear from both his aunts, his uncles, and his family members as to the type of person Johnathan Quiles is and will continue to be. Now, the state has brought up the aggravators. Again, ladies and gentlemen, you must find him or find those aggravators unanimously. In going through our mitigators that we intend to present, you only need to find a mitigator will outweigh their aggravator in order to find for life in prison. And each one of you can hold that individually. This is not a collective group. You can find your mitigators outweigh their aggravators, and in doing so, you can stand by and hold your abiding belief that death is not the only option. In doing so, The mitigators, again, more of which you will hear through the course of the day, we believe you're going to hear that since his arrest, that Johnathan Quiles has become a trustee at the jail, which is unheard of for somebody who has been accused of a crime of this nature. Not only is he a trustee, he has taken up religion. He reads the Bible to other inmates. He does and has provided to the elderly and the infirmed in the jail and takes care of them. And we believe that the testimony you're going to hear from Dr. Rohr is that although you have found him guilty of this, he can flourish in a controlled setting and provide to those others as such. That, in and of itself, we believe, as you hear these mitigating factors, can and should outweigh the death penalty. Life is always an option. He can be a productive member in a controlled setting and in this facility and provide to others who need assistance. Johnathan Quiles, although he is in jail, has no cognitive or neuropsychological deficits. You've heard from his brother who testified here today through the course of the trial. You will hear from him again today as to why you should consider sparing his life and giving him life. The same person who testified in the guilt phase will testify again here in the penalty phase. Again, you will hear that Johnathan Quiles does have a loving relationship with his 5 children. And again, he's a dedicated and hard worker, and that since his arrest, he has no disciplinary reports. He has not gone out and sought more problems, more trouble. He is not fighting in the jail or creating or committing new crimes. That is, again, significant in and of itself. For somebody who's alleged to have committed a crime of murder and sexual battery, he is not going out seeking out new crimes or committing new crimes. At the end of the day, again, ladies and gentlemen, you are the trier of fact. Listen to the aggravators, listen to the mitigators, and keep in mind, one mitigator alone can outweigh their aggravators in your contemplation of sparing Johnathan Quiles' life. And at the conclusion of our testimony, we hope and believe that you come back with that of life in prison. Thank you.
Thank you, Mr. Davis. State, you can call your first witness.
Your Honor, the state would first call Paula Dixon.
Ms. French, I'm going to read the jury an instruction once Ms. Dixon's sworn in.
Yes, sir, Your Honor.
Ms. Dixon, good morning to you, ma'am. Just come over here to your right. Watch your step as you come forth. If you need a glass of water or something, let us know. We're able to certainly get you a glass of water. You can adjust the microphone as you deem necessary, okay?
Oh, thank you.
All right. Yes, ma'am. Members of the jury, I mentioned this to you in my preliminary instructions to you. I'm going to read it again given the witness. The state's now going to present in victim impact evidence to you. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. Ms. French, you may inquire.
Thank you, Your Honor. Good morning.
Good morning.
Please introduce yourself to the jury
My name is Paula Dixon,
and spell your last name, please.
Dixson.
And ma'am, are you related to IS?
Yes, I am.
And how?
I'm her aunt.
And are you Kim Mobley's sister?
Yes.
And Ms. Dixon, did you provide a victim impact evidence statement?
Yes, I did.
And would you please read verbatim your victim impact statement, ma'am? And take your time.
Absolutely. Your Honorable Court, my name is Paula Dixon, and to the family it was no secret that I was Iyana Sawyer's favorite aunt. I remember the day she was born like it was yesterday. I received a call advising me that my sister had gone into labor. My husband and I gathered our children and met my mom and my sister at the hospital. After hours of labor, Iyana Michelle Sawyer made her grand entrance into the world, and it was love at first sight. My Princess Yana Boo was the perfect baby. Her smile was so contagious. This was my sister's first child, so she did everything by the book. I literally watched her embrace her new role as a mother. We had our first birthday party at my house, which I will never forget. I said, Yaya, what do you want to eat? She pointed to the plate and said, beans. We pulled out the smash cake, and she sat on my lap as I fed her. My sister came up with the bright idea to push her face in the cake, which I simply refused to do. Instead, I took her hand and stuck it in the cake. She turned to me, held out her hand, and said, it's dirty. It tickled me something serious. Shortly thereafter, Maya was born. My sister couldn't wait for her daughters to finally meet. My two nieces were inseparable from that moment on. My mother raised us to always be there for your sisters, and I can see that my sister was ensuring that our next generation would do the same. In years to come, she would gain 2 additional brothers. Being the oldest, she became a natural-born leader. She would teach her younger siblings how to read, write, do math, and a plethora of other things. She utilized the leadership skills that she gained at home to pursue other endeavors at school. She was an honor roll student, a crossing guard, and a great friend, to name a few things. She was the definition of, if I can believe it, I can achieve it. She never let a challenge stop her because she knew she could do or be anything she put her mind to. At an early age, we saw that she strived to be the very best and that she always wanted to be a top performer. As a family, we encouraged her to never settle for less because we knew she was destined for greatness. She began receiving scholarships when she was in elementary school, and by the time she entered middle school, she was in honors classes. She began doing extracurricular activities such as playing the violin and joining the step team. As she entered high school, she began taking college courses and was on track to graduate early. She loved to dance and had the craziest sense of humor. One time she called out to one of her brothers, telling him that she needed help. He came running in to see what was wrong, and as soon as he hit the kitchen floor, boom, he slipped and fell on the dishwashing liquor that she put all over the floor. She got a good laugh off of that one. This is just one of the many jokes she played on her siblings. She was the best big sister and very big on family. She was truly her mom's little mini-me. Her siblings looked up to her. As time went on, she became a big cousin. The babies just loved her. My nephew was so crazy about her. One time she was sitting at the top of the stairs, and he began climbing up the stairs to get to her. He made it about halfway and said, Yaya. I guess it made her heart melt because when she went down the stairs to pick him up, she was such a diva and a true fashionista. I started getting her lotions and fragrances from Victoria's Secrets, and she immediately fell in love with the pink line. She knew that for her birthdays and Christmas, she was getting something pertaining to pink. The smile on her face when she opened her gifts was priceless. She loved to eat. We would have family gatherings regularly, from seafood Saturday to Sunday dinner. Thanksgiving was one of her favorite holidays. I started a tradition letting the kids spend the night so they could help prepare the meal. She loved being around family. Her smile lit up any room that she entered, and she was such a joy to be around. She was our princess, and she wore the title well. As time passed, we received shocking news that she was pregnant. I was so excited to be a great aunt, and I could not wait to find out what she was having. It was almost Christmas time, so I made a big Sunday dinner, and everyone came to my house to paint nutcrackers. I guess the baby liked the greens because she started moving around, and I said, uh-oh, the baby's gonna like my cooking. Never in a million years did I imagine this would be the last time that I saw her. The following Wednesday, I received word that she didn't come home from school. I can never put into words the feeling of panic that came over me. From that moment on, our lives would never be the same. We called and texted her for weeks with no response. After a while, we received the news that no one wanted to hear. She was gone and never coming back. We had to tell our children that she was gone while holding back our tears as we wiped theirs away. My poor sister had to keep herself together because she had 3 other kids looking to her for comfort. Their sister was gone. I can only imagine how my niece felt having to look at an empty bed day in and day out. My poor nephew struggled to cope with the fact that she was never coming back. I watched my sister stand still for almost 5 years. Her baby and grandbaby were gone without a trace. All the sleepless nights, the tears, the pain of not being able to give them a proper homegoing, the family dysfunction. This tore our family apart. I had to sit back and watch my sister try to make it from one second to the next. There were no words of comfort we could offer. All we could do was be there. I had to take time off from work to try to get my mind right. Sometimes all I could do was cry. I had to hold on to my faith because that was my baby. I will never forget the many nights that I had to comfort my child. We were at an all-time low. I watched my family completely fall apart over the years. There were so many ups and downs. This loss left a hole in our hearts that can never be filled. How do we move forward as a family? We kept our faith and awaited our day in court. I sat in the courtroom every day and watched my family testify one by one. My heart broke all over again. It was not all for nothing. Justice was served. But how do we pick up the pieces knowing what we know now? We will never truly heal. How can we? Grace and mercy has carried us thus far, and we must hold on to his word. There are so many things we will never be able to do. We will never be able to meet Hazel, never get to see our princess as a mother. We will never see her go off to college. We will never see her get married. We will never see how great she would have truly been. We will never get to see her live. Now we are left with memories, a bunch of what ifs. We must live the remainder of our lives with a bunch of regrets, because we can never turn back the hands of time. We must live with a constant reminder that our princess is gone. We must live with the guilt of knowing that even though we were our sister's keeper, she is no longer with us. That's a burden I wouldn't wish on my worst enemy. We must now figure out how to proceed as a family going forward. How do we heal? How do we trust? How do we live given all that we've learned? The only answer I could come up with is by the grace of God. I know that my God is a faithful God. He will never leave us or forsake us, and he will never put more on us than we can bear. Justice is just the beginning of our healing process. We must now learn how to live with the unimaginable loss that we have suffered. I know our princess is still with us every time we see a rainbow, pink skies, or a red cardinal. We know she is there. I thank God for the 16 years that he allowed us to be in her presence. The world will never know how great she really was or could have been. She will live in our hearts forever. I like to think of her as an angel that my God called home. He needed her more than we did. The flesh wants us to hold on forever, but that's human nature. To my Iyana boo, I love you unconditionally. You would take it from us too soon, but we will continue to honor your memory until we meet again. You are loved, and we miss you so much. If he brings you to it, he will bring you through it. I love you unconditionally. I don't know how, but we will get through this. Long live Princess Yaya and Princess Hazel. Thank you.
Nothing further, Your Honor.
No questions, Your Honor.
I can go.
Yes, ma'am.
Thank you.
State.
Yes, sir, Your Honor. The state would like to next call SS.
Ma'am, good morning. Watch your step. If you need a glass of water, let Mr. Gray know. He'll certainly accommodate you.
So, right here.
State main quiet, you're ready.
You just please reintroduce yourself to the jury.
Iyana Sawyer.
And are you the sister of Iyana Sawyer?
Yes.
And did you provide a victim impact evidence statement?
Yes.
And Ms. Sawyer, will you please read it verbatim to the jury?
Yes. From now until the day I perish, there will always be an element of my life that will be permanently missing. That element is Iyana Sawyer. Our lives were so intertwined, everywhere we went, we were asked if we were twins. In fact, you would rarely see one Sawyer sister without the other. However, now you would never see me or my sister together. Iyana was my older little sister. She was so childish she could make you laugh at the most inappropriate times. But that's what made her so special. She was the beam of sunlight that could peek through a hurricane. We could be grounded all weekend, and yet she would still make it feel like it was a normal day. Iyana was extremely intelligent. She wanted to be a pediatrician. We planned on going to college and becoming physicians together. We planned our lives around each other so much, we even decided that each of us would live on opposite sides of the Riverwalk with apartments facing each other. Unfortunately now, I am completing those same milestones by myself, with every accomplishment bringing great sadness. For every congratulations, the thought that I should not be my mother's first child to graduate, attend college, or move into an apartment crosses my mind. It's extremely difficult to step into my childhood bedroom and see one bed where there used to be two. Every loving memory that I have of my sister has always been overshadowed by the fact that memories will be all that I can carry with me in life. I'm always saddened by the fact that I will never be able to hear her voice, argue over whose shirts is whose, know her daughter Hazel, or see the beautiful woman and mother she would have become. After the announcement of my sister's disappearance and death, school became another place of torment for me. Every day, people I have never met, who I have never seen before, would approach me and ask if that dead girl was my sister. There would be times where I would randomly have to leave school to go downtown to the police station. There were so many occasions where there was little to no notice, and most instances I would be there late into the night. Still, even that did not compare to the misery I endured within those school walls. There would be days where I could not fathom the thought of walking through school doors. On those days, I would sit in the car until the end of the school day and just cry. However, when the 2 o'clock bell rang, I had to compose myself as if I was not in disarray, so my younger brother did not see the mental instability the situation has forced upon me. As I now have to be their source of comfort, just as Iyana was for me. On numerous occasions, the dismissal process from school would be a battle in itself, as media stations would linger to report their stories on my sister's disappearance. Throughout the time Iyana has been gone, day by day, individuals have questioned my mother's parenting. It's very difficult as a teenager to see those who have only read about my mother's question how she raised my siblings and I. Might I add, my mother was and is still an exceptional mother. I remember nights seeing my mother crying on her closet floor, blaming herself for Iyana's devastating loss. There's nothing that I can do ever to lift that burden from my mother, but assure her that it was not her hands that caused Iyana to no longer walk this earth with us. As if it was yesterday, there will always be an image ingrained in my mind of my mother walking through the front door with bloodshot eyes. That was the night my brothers and I were informed of Iyana's passing. Seeing my mother never agree to make sure that her children could grieve will forever weigh heavy on my heart. As I think about how my family has changed forever, I think about how my fiancé would never meet the sister I speak so highly of. My sister will not be my bridesmaid at my wedding, or the fact that our future children will never be able to play together. My family will forever have an empty space that can never be filled by anything or anyone. Some nights I have vivid dreams of my sister, as if it was a normal day that we would spend together. But then I am forced to open my eyes and realize that it will only ever be a dream. All I can ever do is cry and wait for the day I will see her again. Then there are other nights where nightmares are endless. The disappearance of my sister has caused me a great deal of mental instability. I just can't understand how someone who is loved and carrying life herself can be thrown away as if they were trash, as if they meant absolutely nothing to anyone. Iyana was loved. Hazel was loved. Iyana was my compass whenever I felt lost. She was my best friend. There was a point where I could not fathom going through life without her, but I know she would not want me to be anything less than great in life. There's not a day where I don't miss her or cannot stop replaying her smile in my mind. What I would give to have just one more day with her. Even if we are arguing throughout the entire day, I would be extremely grateful. I never took into consideration the phrase, you never know what you have until it's gone. Until I was informed that Iyana will forever be gone, as it was then that I learned that half of me will forever be gone. Though she would never have a resting place, her loving memories will forever rest within my heart.
No further questions, Your Honor.
Nothing from the defense.
Good to see you again.
Thank you.
Anything further from the state?
No, Your Honor, state rests.
Defense. Members of the jury, I'm going to take a 10-minute break real quick. We'll have an idea of what direction we're going thereafter. It's 11:40. Any longer? Okay, we'll come back at around 11:55. We'll go from there. All right, the jury's outside our presence. You guys may have a seat. I still have counsel for the state defense. Mr. Quiles present. You just want a break?
We're ready to go. We just were going to ask for a 5-minute, but I need a little bit longer. That's no problem at all. But we're ready to go. Dr. Roars, and I'm prepared to be called.
It's already almost 12 o'clock. How long is Dr. Roar going to be? Just so I know for the jury's sake. I'm happy to go ahead and give the jury a lunch break now and just tell them, go ahead and go to lunch. See you back at 12:45. just so you guys know, my plan would be at this point, have you finish your case. If I'm assuming you can finish it this afternoon, we'll see how long it takes, and then just do closings tomorrow morning.
And Judge, just from our perspective, we would be prepared to do everything today. I do not expect that it would take all afternoon to get through those character witnesses. I think if we could get Dr. Rohr done this morning before they go to lunch, and then when they come back from lunch, I don't expect that those other witnesses would take longer than an hour and a half in total. I just don't expect it to be there that long.
Okay, I don't want to send the jury out to lunch at 1 o'clock, though. That's my only, I didn't tell them to be prepared for a late lunch. 1 o'clock is on the latter end. I'd rather just send them home now, or send them away for their lunch break now, and just this 5-10 minute breaks encompassed in their lunch break, and we'll go forward this afternoon. Does the doctor have a conflict that's going to create a timing issue?
No, not at all, Judge. It's just we don't expect it to be lengthy.
How
Bob estimates that his direct would be at max 30 minutes, and I know that the state might have a little bit to say, but I don't expect it to be longer than our direct by any means.
I'm fine with that, the court's proposed schedule, to just give them their lunch break now.
I mean, they heard some powerful testimony. Let me give them a break.
Of course.
That may be the wisest thing to do. It's 11:45. I'll have the staff let them know that they'll have till 12:45 for lunch. So if that's 12:45. Let's say Dr. Rohr's an hour. That's 1:45. You think we're closing by 4?
Judge, I would be shocked if we were not done well before that. I think that we'd be perfectly fine to do closings today. I've spoken to the state about the length of theirs. I think both of our closings together would be an hour, maybe slightly longer for the state, depending on what he said. But so I think we could get it all done today, Judge.
All right, I'll make a judgment call I'll make a judgment call this afternoon. I don't want them closing and being charged at 4:30, 4:45.
Understood, Judge.
That's my preference. They may have a different preference, but
The state will be prepared for closings as well.
okay.
Yeah, whatever the court wants, Judge, we'll comply. We're ready for today. If we need to do it, and there's plenty of time, we're prepared to move forward.
Okay, and what I'll do is I'll have courthouse IT. So number one, please let the jury know they have till 12:45 for lunch. 12:45. And then I'll have courthouse IT in here setting up the courtroom for Zoom purposes for your witnesses this afternoon. Just so you know, there's a camera on the evidence cart. That will essentially be your camera. The clerk will go over there, swear them in. That monitor, what you see on the evidence cart, will be on all the devices in the courtroom, and the audio will be hooked up. So essentially, they're still using the audio in the courtroom, just like you do in first appearance court or like you do in a typical courtroom with Zoom nowadays. They recommended that would be the easiest process, and you have the Zoom ID, and I can control that up here as well.
Yes, Judge, and I've already provided the Zoom ID to the witnesses, the 3 witnesses that will be appearing via Zoom. And we did test, not on that Zoom number, of course, but on their devices. I've gone through that with them, so I'm hoping we have no issues today whatsoever. But we
Okay, just give them a time that they can Zoom in, and we'll leave it up to you to make that time work, and I'll work if it fits in with your schedule or you want to move things around, whatever you want to do.
Yes, Judge. Now that we know the schedule as far as lunch, I will call them and make sure that we know that during this break here that they're available and try and get them on this afternoon.
Okay. Anything else we need to handle outside lunch? If we are going to closings today, I ask you to look at the final instructions. The one question I had stated is that part of the final instructions include if they put it in a lack of record, I think he has a possession of marijuana charge. I'm not sure if you want that to rebut the lack of record, if that's worth it to you. Please take a look at that and let me know the state's desire. Everything else in the final instruction should be rather absent the mitigating circumstance, which I read, which I asked you to go over again to make sure that's the list in the order you want it. You don't want to combine anything or separate anything further out. Just take a look at it. I did it the way you guys proposed, since I figured that's why you put it in the pleading that way. Just take a look at that, and we can discuss that. Maybe get here at 12:35, and we'll discuss those issues.
Yes, Judge, I think there's a way to consolidate just a little bit so it's a little clearer and not repetitive for several of them. So we'll do that over this break and make sure we have that to you. So we do plan to give you something additional from what you
do it over the break, or what I would ask you to do maybe easier is copy and paste those mitigating circumstances into a separate Word document, work off that Word document, and then maybe email it back to me over the break. Email it to me back over the break, and we'll take a look at it.
Yes, Judge, we'll do that.
All right. See you guys at 12:35.
Thank you, Judge.
Back on the record. 518. I have counsel of state defense, Mr. Quiles present. I wanted to talk about the jury instructions. Was made from either side. So what you'll see is I don't think the instruction for defendant is applicable for this phase of the proceeding. Instructions I read to you phase. So I just need to Anybody have anything to say?
As we defer to the defense,
Judge, give me 1 second.
Sure.
Defense agrees that 6 and 7 can be removed. Wait.
How about 89, 89? Is it applicable to this phase of the proceeding?
defense wants it in, we'll agree. If they want it out, we'll also. I agree with you. It's just a statement. The next several witnesses were deposed. The other issue, Judge, too, is, as you've heard us say, in essence, we're all our aggravating factors.
And I think the instructions say it refers back to other instructions.
It's fine with the state to leave it if
Accomplice and informant testimony.
we agree that should be removed.
Defense, along with child I'll even witness it comes out.
And Judge, maybe just for the record, as far as 8 and 9 go with Wayne, not relevant to anything that's going to be presented today, I can put that on the record.
They did not want it in. They were deferring to you.
Oh, you want it out? Oh, I thought you were saying leave it in.
So the inconsistency.
I misunderstood. I thought that they were saying to leave it in. If they said to remove it, we agree.
Okay, leave it out. I'm taking it out.
State agrees.
Is how you're handling his prior misdemeanor. I'm assuming it's a misdemeanor.
Significant history of problems.
Okay.
We don't intend on, and their doctor is going to admit to some previous marijuana use, so they're circumstance with additional evidence. We made an argument, though.
Synced. And then the standard instructions that flow from that with the mitigating circumstances. Deliberation forms that I previously. This updated copy with counsel.
And list of mitigating.
Okay. You have a list for me?
You want to do that now?
You have a list for me?
And just tell you the ones that are.
So you're just taking some out.
Ones, but I don't know if that just for time's sake. I know that I don't want the jury waiting on us unless you want to wait and do this.
Why don't you know?
Number 10 is repetitive. Number 23.
into court.
Members of the jury, welcome back. You guys may have a seat, of course. I'm now going to look to the defense for their case. Mr. Davis, Ms. Michelle, you may call your first witness.
Dr. Jennifer Rohr.
Dr. Rohr, please. Good morning, good afternoon, doctor. Come on forward to be sworn in by the clerk.
You solemnly swear affirm the testimony you give will be the truth, the whole truth, nothing but the truth, so help you God. I do.
Good afternoon, doctor. Let's watch your step as you come forward to your right. Need a glass of water, let us know. We'll do our best to accommodate you.
Thank you.
That said, Mr. Davis, remain quiet. You're ready.
Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
Would you state your name for the court?
Jennifer Rohr, R-O-H-R-E-R.
Where are you employed?
I'm self-employed as a clinical and forensic psychologist in the states of Florida and Virginia.
Okay. And can you tell the court what your educational background is, please?
Sure. My highest degree obtained is a PhD in clinical psychology from Kent State University, followed by a pre-doctoral internship in forensic psychology at Florida State Hospital, followed by a postdoctoral residency in forensic psychology at Georgia Regional Hospital in Savannah.
Okay. And after you completed your education, where were you employed after that?
Many places. I started off as a forensic psychologist at South Carolina Department of Juvenile Justice, doing post-adjudication evaluations of juveniles. I also worked at Dorothea Dix State Hospital, which is one of the oldest forensic hospitals in the United States, also as a forensic psychologist. Moved to Washington, D.C., where I worked for D.C. Superior Court as a forensic psychologist. Also taught at George Washington University in their forensic psychology program, and also developed and ran a forensic psychology program as department chair at the Chicago School of Professional Psychology. During that time, I also assisted with the Alexandria Police Department, teaching police officers how to interact with people with mental illness. I then relocated to Florida in 2016 and have been in private practice since that time.
Okay. And how many times have you testified in court?
About 300.
Okay. And have you also worked on other cases of this nature, capital cases and homicides?
I have, yes.
How many of those?
Maybe between 50 and 75.
And how often do you render an expert opinion?
In court or just for an evaluation?
Any evaluations, how many have you done?
I've conducted over 7,000 evaluations in the course of my career.
And how many opinions have you rendered in court?
Well, about 300 when I've testified.
Judge, I'd offer Dr. Rohr as an expert in psychology.
objection, so continue.
Okay. Thank you. All right, ma'am, did you have an occasion to go or occasions to go and meet with Johnathan Quiles?
I did.
Okay. And as going over there and meeting with Mr. Quiles, what is part of your process as far as going through and preparing an evaluation and psychological eval?
Sure. So I review all the available legal documents with which I'm provided. I met with Mr. Quiles a total of 3 times for about 4 hours at the jail. I collected background information from him in terms of family, educational, employment, mental health, substance use, and criminal history. I also conducted a mental status examination to identify or observe any possible signs of mental illness or intellectual disability or psychiatric impairment. We also did some psychological testing. I administered a brief IQ test and also a personality assessment inventory. And then I wrote up a report after speaking with his aunt.
Okay. Now, in going through this, some of the factors that you take into consideration, I know you said you went over all the police reports and evaluation, or police reports and all of the evidence that was provided to you as best you could. Now, after speaking with his aunt, what were some of the factors that you came to use in doing this?
Are you asking the factors that I felt most relevant in the case?
Yes.
Yes. So based on his self-report and speaking with his aunt, I learned that he had been raised in a high-crime, poverty area of New York, that his mother suffered from mental illness and also, his wife, I apologize, his wife suffered from mental illness and substance abuse. His mother passed away in 2010 from bone cancer. I think that her death was extremely challenging and hard for him. They were very close, and he described himself as a mama's boy. I learned from his aunt, and Mr. Quiles confirmed that his dad was largely absent from his life, and when he was present, he was a negative influence. I believe Mr. Quiles referred to him as a schemester. I believe his dad had a pretty extensive criminal background from what I understand. And then also he reported a history of childhood physical abuse by one of his mother's former boyfriends.
Okay. Did he also self-report drug use?
He did. He told me that he began using marijuana, it was at age 11, and had used alcohol regularly since age 13 or 14. He did suggest that the alcohol abuse was encouraged by his family, that it was normative in his family to be drinking a lot.
Okay. And also, as part of your assessment, can you tell the court when or what his school and education was?
Sure. He withdrew from the 7th grade following the birth of his first child. And that was the highest grade he attained. So he completed the 6th grade.
Okay. And did he become gainfully employed after that?
He did. By all accounts, he's maintained employment and has been successful at all of the jobs that he's been at. Lastly, at the junkyard.
Okay. And did he tell you some of the jobs that he held?
He did. He said not only did he work at the junkyard, but he had previously also worked in construction, maintenance, and as a truck driver.
And as part of your assessment, you said you did an IQ test. What were the results of that?
He obtained a full scale IQ of 90, which falls in the average range.
Okay. And despite not having completed any school?
That's correct.
All right. Well, I shouldn't say any school, but moderate school. He didn't get through the high school.
Correct.
Okay. Now, in addition to that, as part of your assessment and going over to the jail, what were some of the things that struck you as significant in meeting with him and going over his records?
Each time I went to the jail and signed in, I spoke with the officers, both in public reception, which is the entrance to the jail, and also up on the floor, on the 5th floor where he's been housed each time I've seen him. Every time I've gone there, numerous officers have told me he's been a model inmate, which is very surprising. They actually assigned him to be an alternate trustee, which again is highly unusual given the nature of his charges at the time. Even during lockdown, when the other inmates were locked in their cells and weren't allowed to come out, Mr. Quiles was given the opportunity to even clean the jail, even in the restricted areas where there were no cameras. To my knowledge, he never abused that privilege, and that suggests some level of trust by the correction officers that they could trust him to be around the jail, around phones, around possible contraband. And to my knowledge, he never took advantage of that because, to my knowledge, he has no disciplinary records, DRs. I also learned that he often read the Bible to those inmates who could not read, and that he helped care for some of the more vulnerable inmates at the jail.
Okay, and as far as when you say more of the vulnerable, can you expand on that, or what you mean?
I was told that he had assisted some of the elderly inmates and also just less vulnerable, those that probably could not protect themselves from the more aggressive inmates in the jail.
Okay. Now, in your years of doing this, is that pretty, I mean, I know you use the word rare, but I mean, in your years, have you ever seen someone with a charge of this nature working as a trustee?
I have not. I was very shocked when he told me, and I did verify it because I was so surprised by that fact.
Okay. And how many years of that, of you doing this, have you been, or how many years have you been doing this?
Since 2005.
Okay. So 18 years?
About, yes.
Now, besides that, in speaking with his family, what were some of the other notable things that stood out as far as Mr. Quiles?
I spoke with his aunt. She described him as extremely generous with his time and assistance, always willing to help others. She described him as a very good father, a very hard worker, said that he would do anything to help anyone in the past and would continue to do so. She also noted that she felt, in her opinion, that a lot of his problems early on were due to the absence of his father. She indicated that they had reconciled somewhat prior to his arrest in this case, but she did feel that that was an absence in his life, that his father was not present.
Okay. Now, as part of your assessment, what is your overall thoughts of how he could be productive as an inmate if it were considered to be life?
I mean, I think he has shown over the past 5 years in the Duval County Jail that he hasn't violated the trust that the correction officers have given him as an alternate trustee. He's had no disciplinary action or reports. He has helped other inmates, particularly the elderly and the vulnerable. I feel as if in a structured environment, he could be as productive as one can be in a prison setting.
Okay, so as you stated, in a structured environment, so in a setting such as that of at the state prison, then he could be a productive member as an inmate.
Yes.
And be able to assist others.
I do believe that, yes.
Okay. And to be clear, life is that. He has no opportunity of parole or anything else, correct?
Correct.
All right. And is there anything else that in your review of his records and everything that you've gone through that you feel would be notable for this court to consider and for this jury?
I don't think so. I think we've touched on everything that was part of my evaluation.
All right. Judge, if I may have a second with counsel. Just briefly, ma'am, in going over your assessment, you did what's called a PAI, a personality assessment inventory.
That's correct.
What is that for the court?
It's a personality test. It's probably the second most widely used personality test in the entire world. It assesses both personality characteristics, but also any type of psychopathology, so any types of mental health concerns ranging from depression to schizophrenia to insomnia to anxiety to substance use disorders. And then it also looks at those personality traits and how one interacts with the world and the people around them.
And as part of your assessment, what are your findings?
Based on the testing results, his testing results were valid, meaning he was genuine and honest in responding to the questions. His results did suggest a personality style or personality characteristics consistent with an antisocial attitude or tendency.
Which means what, if you don't mind, in layman's terms?
Sure. So his results are consistent with an antisocial personality disorder. Antisocial personality disorder is a condition in which one's personality characteristics or traits are often maladaptive or unhealthy and impair functioning in a certain way. In this particular personality disorder, the antisocial, it's typically violating the rights of others. It could include criminal behavior, but it doesn't always need to be criminal behavior. It could be manipulation. There could be some arrogance, some entitlement, deceitfulness, if I didn't say that already. But we often think about it going along with criminal behavior.
Okay. And for lack of better words, narcissism?
Yes, narcissism.
Okay. Anything else?
The testing revealed conflictual interpersonal relationships, a lot of problems with interpersonal relationships based on the testing.
When you say that, can you give an example, please?
Sure. Again, this is based on testing, but based on the testing, which again was valid, it suggested that a lot of his relationships have a lot of conflict. He may be impulsive, egocentric, angry, may lash out at others in the context of those interpersonal relationships, may be very impulsive when he lashes out, feeling that he has been slighted in some way.
Okay. And as a result of that, most of his relationships don't last a long period of time. Would that be accurate?
I'm sorry, could you ask that again?
Do most of his relationships only last for a short period of time? Or conflict in the relationships?
I mean, based on the testing, his relationships, whether they're short or long, tend to be characterized by high conflict.
All right. Nothing else, Your Honor.
Please, court. Yes, sir. Good afternoon, ma'am.
Good afternoon.
Just a few follow-up questions for you. Ma'am, now you saw the defendant on 3 occasions. Is that what you testified to?
Correct.
Yes, ma'am. And doctor, did you see him on June 28, 2023?
Correct.
June 29, 2023?
Correct.
and July 21, 2023.
Correct.
So you first saw him approximately 90 days ago. Is that correct?
Yes, that's correct.
And you'd never seen him prior to June 28, 2023?
No, I have not.
Hadn't talked to any correctional officers about him all the way back to 2019, 2020, 2021, or 2022?
No, never.
The only ones you talked to were during the 90 days or so that you met him?
Yes, when I went in to check in and see Mr. Quiles.
Okay. And in fact, you authored your report on August 23rd, 2023, right?
Yes, that's correct.
And if your last visit was July 21 of 2023, that means you really only were at the jail talking to correctional officers between June 28 and July 21 of 2023, correct?
Yes.
So about 30 days of a sample size is your testimony with respect to who you talked to over there?
Well, those are the times I spoke with the officers.
Sure. You looked at records as well.
I'm sorry?
You looked at records as well, correct?
I did, yes.
Okay. Now, your 3 visits also included a total of about 4 hours you sat down with him?
That's correct.
Did you listen to the 2-hour wire that the jury heard where he was corresponding with 2 other inmates?
Unfortunately, no.
You never heard any of that?
I did not.
Now, you told us you interviewed one other family member, and that was an aunt. Is that correct, ma'am?
Yes, sir.
You didn't talk to any other family members?
No, he asked me to speak to his aunt.
All right, that's where I was going next. Did he only ask you to speak to his aunt?
Yes.
Now, ma'am, you also kind of went over some of the testing that you did. Did he tell you as part of your testing or in your interview process that he had 5 different children?
Yes, he did.
All right. And did he say that those marriages failed due to his infidelity?
He said the first one failed due to infidelity on his part.
All right. And he also told you he left school after the 7th grade during his 7th grade year, correct?
Withdrew from the 7th, correct.
All right. And he did that because he had his first child?
That's what he said, yes.
Now, you agree you did not diagnose him with any kind of mental illness? Do you agree with that?
So technically personality disorders are classified as mental illnesses according to the American Psychological Association, but they are distinct from mental illnesses that we think of like a bipolar disorder or a schizophrenia or a depression.
Okay.
They're different. They're qualitatively different.
Isn't antisocial personality disorder basically characterized by disregard of other people?
Yes.
That was your diagnosis of him?
I actually diagnosed him with a mixed or an unspecified personality disorder because I saw features of both antisocial and narcissistic personality disorder. So the 2 of them combined.
Now, but you also saw no history, either in records or in your interviews with him, of any kind of depression?
No.
Suicidal ideology?
No.
And did you inquire of him about whether he entered a substance abuse program at age 15?
I did.
What did he say about that?
He told me that he voluntarily admitted himself to a 2-year substance abuse treatment program at age 15 to get away from his family, his neighborhood, just to get away.
All right. Now, doctor, do you agree the defendant is fully oriented?
Yes, absolutely.
You agree he's friendly?
Yes.
Engaging?
Yes.
He has the thought processes that are coherent and relevant?
He does.
He's not distracted by any kind of internal stimuli?
Correct.
He's not delusional, correct?
He is not.
You believe he is adequate with respect to attention and concentration issues?
Yes.
He has no memory issues, correct?
Correct.
No intellectual disabilities of any kind?
No.
In fact, you've described him as being average, correct? With
Yes.
respect to his testing.
Yes.
Now, you chose in your testing to give this PAI, that's a personality assessment test?
It is.
All right. Is that where you glean the personalities that you described at the end of your direct examination?
Are you referring to the diagnoses?
Yes, ma'am.
The diagnoses are based in part on testing, but also on one's history and also current presentation.
Well, one of those you said was, quote, conflictual interpersonal relationships, end quote.
Yes.
That's how you described them.
Well, yes, that was based on the testing.
Okay, and what does that mean?
Conflictual relationships?
Yes, ma'am.
One having trouble in interpersonal relationships. It could mean a variety of things. The testing, and I did mention this briefly a couple minutes ago, according to psychological testing, his conflictual relationships are because, in my opinion, because of his maladaptive personality traits of being hostile and impulsive and egocentric, entitled.
So that includes interpersonal relationships with significant others.
Sure.
Not just immediate family members like his father or his mother.
Yes.
Any relationship.
I would say most, if not all, yes.
All right, and I think if I heard you correctly, you described him as impulsive. Is that correct?
Yes.
Self-centered?
Yes.
Hostile?
Can be, yes.
And also I think you testified that he lashes out impulsively against one who slights him. Is that correct?
Based on testing, yes.
You described him as egocentric.
Yes.
Hostile?
Can be.
I think you said angry as well.
I did.
Now, does the testing show you that he externalizes blame? And if so, will you explain that?
I don't know if that was specific in the testing, but that kind of falls under antisocial personality disorder. Typically those with that personality disorder and the other personality disorder, narcissism, they tend to externalize blame, project blame. It's someone else's fault.
All right. Now, that was my next question. That's somebody who describes situations as not his own fault, not of his own doing.
Correct.
And that's how you describe the defendant.
He does externalize blame, yes.
One moment, Your Honor. Nothing further, Your Honor. Thank you.
Just briefly, Dr. Rohr, now, despite those issues that you just went over with the state, as well as with myself earlier, Johnathan Quiles can be a productive member as an inmate if he were to be considered for life, correct?
I believe so. I believe he has shown that by what I've learned about his behavior at the jail, and again, no disciplinary action. Now, whether his behavior in the jail is altruistic, meaning he truly wants to help others, or whether he's satisfying his own narcissism, I don't think that matters. I do think he's demonstrated for 5 years in the Duval County Jail that he can go without getting into trouble, breaking their trust, breaking the law, getting new charges. So yes, I do think he can conform his behavior despite what motivation that might be.
Okay, and to be clear, have you ever seen someone with these type of charges be a trustee?
I have not, no.
No further questions, Your Honor.
Doctor, good to see you, ma'am.
Thank you, Your Honor.
The rest of your day.
You too.
Mr. Davis, Ms. Michelle, you can call your name, please.
Your Honor, we can next call Iyana Pugh.
Officer Hill, can we get Kashana Pugh, please?
solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
Right this way, ma'am.
Ms. Pugh, good afternoon to you, ma'am. Just watch your step as you come forward. Need a glass of water or something, let us know. Mr. Gray and the staff can certainly help you out in that regard, okay?
Okay.
Slide forward.
And you can adjust the microphone to help you project your voice as well. And with that said, Ms. Michelle, you may inquire. You're ready.
Thank you, Your Honor. Good afternoon, or was it? Yes, it is. Good afternoon.
Good afternoon.
If you could please start by introducing yourself to the jury, please.
My name is Kishana Pugh, but I'm also here to speak on behalf of my husband, David Pugh.
All right, and Ms. Pugh, Mrs. Pugh, how are you related to Johnathan Quiles?
Jonathan is my husband's cousin, first cousin.
And how long have you known Mr. Quiles?
About 12, 13 years.
And how often during that time period would you say you've interacted with Mr. Quiles?
I would say maybe every couple months or so, every few months. Now recently, my husband talks to him every day almost.
And what type of interactions would you all have? I mean, like in what settings?
Church. When he first got to Jacksonville, we invited him to church, and he would go to church with us. And also for family events, he would invite us over. He would cook for us and things like that.
Can you share with the jury a little bit of Mr. Quiles' background that you're aware of? And I know you're speaking also on behalf of your husband, David Pugh, so if there's something that you want to offer from his perspective as well, you may do that.
Sure. So from my perspective, Jonathan he's like been the only member of my book club. I want to say he's the only person that actually likes to read with me and things like that. We've shared books and stuff like that. With my husband, he's been almost like a big brother to my husband. He always gives advice. He's helped us. When it came to our renovation of our bathroom, like we showed him the inside. He came up with a whole plan of how we should do that. He would also help out at the church a lot. I know he built like the sound booth at our church. He did a lot of handyman work and things like that.
All right. Can you share with the jury what you know about Mr. Quiles as a person?
As a person, he's always been like this bubbly person. He's always, every time I see him, he has a smile on his face. He's laughing about something. He's always been such a happy person.
Okay. And what does he mean to you for your life and as well? I know you're speaking on behalf of your husband, so you may give his perspective as well.
What he means to
you as a person. Mm-hmm.
I mean, he means a lot. I see that he brings so much joy to my husband. My husband, he's always excited to talk to him or tell him about his day or what's going on. He's been a person of release for my husband. So I feel like he's a very important person in our lives.
And what other information would you like the jury to know as they weigh this evidence that you're providing to them?
The only thing my husband just wanted me to mention is that he loves his cousin very much, and that as a man of God, he believes in redemption, and he believes that everyone should have a chance at redemption.
Is there anything further you would like to offer to the jury at this time?
No, that'll be all.
Nothing further for this witness, Judge.
No questions from the state.
Ms. Pugh, good to see you, ma'am.
Thank you.
Have a good rest of your day.
Judge, if I could have just one moment to check outside who's next. We were going to do Zoom now, but I need to let them know that. Is that okay, Judge? If I just
Of course.
step out really quickly? Thank you.
No, of course. Okay. Members of the jury, just so you guys are aware, we have a few witnesses who may testify via Zoom. We have set it all up. It should work seamlessly. But we have people en route to have it set up because they don't trust me to do so. So that may take a couple minutes. I may give you a few minutes to stretch out in the jury room while we take care of that, but the defense is seeing if an additional witness is here so we can kind of keep going.
Judge, we're ready to call other in-person witnesses while we're waiting on the Zoom to be set up. If we could call Mr. Curtis Hale.
Curtis Hale, please.
You solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Hale, good morning. Good afternoon to you, sir. Come over here to your right.
Right here, Mr. Hale.
Need a glass of water, let us know. We can do our best to accommodate you, of course.
Have a seat, sir.
And with that said, Ms. Michelle, you may inquire. You're ready.
Thank you, Your Honor. Good afternoon. If you could please start by introducing yourself to the jury.
My name is Curtis Hale, H-A-L-E, and I live in Arlington.
Thank you, sir. Can you start by telling us how you know Mr. Johnathan Quiles?
I met Johnathan in Arlington. He was working on a vehicle in my neighborhood, and that's how I got to know him to begin with. And then we become real close friends after that. And he's a good handyman. He helped me with an awful lot of stuff around my house, around some apartments I have, and he even rented from me for a period of time.
Thank you. So how long would you say you've known Mr. Quiles?
Probably about 8 years altogether. About 3 years. About 8 years I've been knowing him.
And you said that you met him while he was fixing a vehicle. Was that when you guys were neighbors?
Yes.
And during that time period, did you get occasions or have occasions to spend time with him?
Oh, yes. Spent a lot of time with him. He helped me build a storage building and did an awful lot for me. And I know he did a lot for the church that he went to. He's told me about the different projects he did with that and everything. I was real proud of him, to have a friend that did work like that, to try to help people out.
And you mentioned that he also rented from you.
Yes.
Did he also work for you at any point in time?
Not directly work for me, just help me out with different stuff. Like I said, he was a good handyman. He'd help me paint, put something together, fix my vehicle, or something, work on my truck. He's just real knowledgeable, and he was just a happy-go-lucky guy all the time. All the dealings I've had with him.
Yes, sir. And can you tell us what he means to you personally in your life?
Well, he's just been a real good friend of mine, and I just think the world of him, I mean, I talk with him occasionally, and just think a lot of him, like he was my son almost,
Thank you, sir. Is there any other information you want to offer to the jury as they deliberate and weigh the evidence that you're presenting?
I'm sorry, I couldn't hear you.
Is there anything else you want the jury to know today?
Just that I think that he's a fantastic person, in my life, Tom. All the dealings I've had with him have been positive. I've never had any negative dealings with him in any way, shape, or form. He can create a lot of stuff. He's just a sharp individual, I think.
Thank you, sir. Nothing further.
Hey.
No questions, Your Honor.
Mr. Hale, good to see you, sir.
That's all?
Yes, sir. Have a good rest of your day.
Thank you.
Ms. Michelle, you can call your next witness.
Yes, Your Honor. If we could next call Karen Gaines McMillan.
Are they getting Miss Gaines? Miss Gaines, come on forward, ma'am.
solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
Ma'am, good afternoon to you. Good afternoon. Just watch your step as you come forward. If you need a glass of water, Mr. Gray and the staff will certainly accommodate you.
Thank you.
With that said, Mr. Davis, you may inquire. You're ready.
Thank you, Your Honor. Good afternoon, ma'am. Would you state your name for our jury, please?
My name is Karen Gaines.
All right. And where do you reside, ma'am?
I reside in Orange Park.
Okay. And how do you know Johnathan Quiles?
I know Johnathan Quiles through my best friend,
Which is who?
which is his aunt,
And who's that, please?
Paulette.
Okay. And how long have you known Johnathan?
I've known Johnathan since he's moved here. I'm not exactly sure how many years he's been here. However, I want to say maybe around 13 years.
Okay. And in the time that you've known him, how often do you interact with Johnathan?
I interacted with him mostly through family gatherings.
Being what kind of gatherings?
Cookouts, holidays, just, if we just get together and decide to do something.
Okay. And what does Johnathan come to mean to you?
Johnathan, he means a lot to me. He's a very caring person. When I went through a hard time, with a divorce, and he was very encouraging to me, and I was really distraught. So he would help me. He would just say stuff like, read this in the Bible, and that you're a good person, and God will bless you, and it's that person's loss and not yours. So he was very encouraging during that time.
Did he help you in any way during the course of those times if you needed it?
No, I didn't need any help with anything, just encouragement.
Okay. So he was there for your emotional support as needed?
Yes.
Okay. And is there anything else you'd like the court to know about your time or what you know of Johnathan?
Okay. I recall a time when they lived off of MLK, and they had he had set up a nice campground in their backyard, and he had the neighborhood kids and my godson. We dropped my godson off over there, and he did an overnight stay for the children, and they just had a great time. He taught them how to box. They roasted marshmallows on the campfire, and he did this mostly by himself.
Okay. So you know him as a very caring and loving person?
Yes.
Okay. Is there anything else you'd like the court to know?
Just in general, I admired the fact that, when he participated in church, he was, whatever his pastor asked him to do, he was willing and able to do it. And if he didn't know how, he would Google it or look it up on YouTube to figure out how to repair something, fix something. So it really didn't matter what it was. He was just willing to do it.
And did you know him as a hardworking person?
Very hardworking, yes.
To the best of your knowledge, he provided for his family and children?
Yes, he did. His daughter was amazing. She really loved her dad. She loved her dad a lot.
Is there anything else, ma'am?
Well, I had a lot to say, but I can't remember at the moment. But yes.
I don't have anything further, Your Honor.
No cross, Your Honor, thank you.
Ms. Gaines, good to see you, ma'am. Have a good rest of your day.
Thank you.
Defense, do you have another witness ready?
Yes, Your Honor. As they're setting that up, I would call, well, we have one other witness in person, then we can switch to Zoom. Since
Okay.
that's ready. We can call KB.
Said KB as in boy.
Yes, Your Honor.
You solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, sir, come over here to your right. Watch your step as you come forward. If you need a glass of water, let us know. Mr. Gray and the staff will certainly accommodate you. And you can use that microphone to help project your voice out to the rest of the courtroom.
Water if you need it.
With that said, Mr. Davis, you may inquire. You're ready.
Thank you, Your Honor. Good afternoon, sir. Would you state your name for the record, please?
Kenneth Bear.
Okay, and where do you live, Mr. Barry? Where do you live? Area of town?
On Merrill Road.
Okay, so the Arlington area?
Yes.
All right. And how do you know Johnathan Quiles?
He's my cousin, but he's like my brother. I've known him all my life.
All your life?
All my life.
Okay. And for those of us that don't know you that well, how old are you, sir?
18.
All right. And, sir, when you say you've known him all your life, can you tell the court and the jury how has he been there for you?
As far as I can remember, he's always been there. Like, there's never been a time where he was not involved. He was always involved with everything that we did. Like, if my mom needed him, he would be there, like, with 10 minutes tops. You know, he was always like that.
Okay.
Yeah.
Now, over the years, when you were in junior high and high school, if you needed something, was he there for you?
Yeah.
Okay.
Well, definitely.
Providing rides to and from places?
Yeah. Well,
Did you participate in sports?
yeah.
Did he take you to and from sports?
He did for a certain point. Yeah, he did.
All right. I see you smiling and getting happy about that. Does that bring back good memories for you?
It does. I'm not gonna lie. It does.
All right. Was he there to support you in the sporting events that he did and the things that you participated in?
Yes, sir. He did. He was. Yeah. He was very involved in my sport. Actually, when I first started playing sports, he was one of the people that were like most adamant about coming. Let me be there. Give me the schedule, and I'm gonna be there. And he made almost every game.
Okay. Specifically, what sports?
Around like when I first started playing basketball, he came, but like mainly around like soccer, things like that. When I first started playing soccer, he was like bring me to and from games. He came. And then when I first started playing basketball, he brought me to a couple of games, but he came to some of those.
Did he also encourage you to make sure you made good grades in school?
Yeah, he said that was the first thing. Basketball and sports was one thing, but school could take you a long way. That's what he used to tell me.
Okay. And specifically, did he tell you to make sure that you got an education because he didn't have one?
Yeah, he made emphasis on the fact that due to his mistakes, he always told me learn from this because I was there. So because of that, he's always put emphasis on education and school.
And was he also encouraging you to make sure that you could go to college?
Yeah, he told me college is a must. He was one of the main people that told me that college is a must. Like, you have to go to college because, and graduate from college as well.
Okay. Is there anything else you'd like to tell the court about your uncle as far as, in addition to the support and things that he helped support you in?
Yeah, he's really just a jack of all trades. He was all he could. Any spots that you could fit him in, he would fit and strive in it. But other than that, he was like very, very simple, very, like he loves his kids. He loves everybody he comes in contact with. You know what I'm saying?
How many kids does he have?
I believe he has around like 4, 5, around. Yeah.
Was he active in his children's lives?
Yes, very, very active in his children's life. He made sure of that.
Did he encourage them the same way he encouraged you?
Yes, whenever his kids would come over and I would be around, he would always have us in the same little thing, and he would just talk to us saying, I'm saying, this is what you should do, this is what you shouldn't do. Make sure you never do this, always strive to do, good, yeah.
Was his focus on making sure that they were a better person?
Yes, he always aimed to make other people around him better.
I may have a second, Your Honor.
Of course.
Is there anything else you'd like to tell the court about Mr. Quiles?
That's about it.
Nothing further, Your Honor.
Any cross from the state?
No questions from the state.
Sir, good to see you. Have a good rest of your day.
I wonder if I could just check Zoom to see who's on, and then I can tell you who's next.
What I'll do is let me give the jury a 10-minute break real
Sure.
quick. And, sir, you're free to go. Go for it. Members of the jury, we're going to make sure Zoom is set up. Just so you guys, I'm not sure what you guys see on your screen right now. Just so you know, the camera angle that you're seeing is on the evidence cart facing straight toward you. You are not captured in any kind of camera angle whatsoever. I just want to make sure you guys understood that. Give me 10 minutes. We'll make sure we're ready to go on Zoom, and we'll go from there. Please remember, don't discuss the case among yourselves or each other. We'll see you back in a few minutes. The jury's outside our presence. You guys may have a seat. I still have counsel of the State Defense and Mr. Quiles present. I'll give you guys a short break other than you guys making sure Zoom's set up. Let's just come back out in about, it's 1:43. I'll see you back at 1:50.
Yes, Judge. And just for the court, for the record, we only have one other in-person witness, and then there will be 3, from what I can see, who are on. So we won't be much longer, especially if there's no cross of these witnesses either.
State, do you have any rebuttal?
At this point, we do not.
What I'll probably do then is I need to make sure the jury instructions are finalized. I'll give the jury a break after these 4, and then we'll go into closings if there's no rebuttal from the state. If I remember correctly, state or defense, please remind me, but I believe at this phase there's no rebuttal close, correct?
There's not.
Okay, that's what I thought.
He goes first, and they have the last word.
Yes, and so I'll go into closings like you guys.
We should be there by 2:30.
Sure. So I'll do it. I'm fine with me. I'll see you guys back at 1:50.
Thank you, Judge.
So you've got one that doesn't have a name.
Okay. So let's admit that person. That way I can get them to change their name. I don't know who it is, obviously.
Okay.
So I want to just do that real quick. We're not streaming, are we?
the audio muted there for a second. My apologies.
And Judge, is it okay if I let her in now, or do you want me to wait to do that?
Go ahead and let her in.
Okay.
That's fine.
Your Honor, the jury's re-entering the court.
All right, members of the jury, welcome back. You guys may have a seat. And we're going to continue with the defense case, and the defense is calling a witness who's present on Zoom. And so you should be able to see on the monitors in front of you. With that said, Ms. Michelle, the defense can call its next witness.
Yes, Your Honor, thank you. If I could next call Vanessa Brassetti.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Ma'am, if you could please start by introducing yourself to the jury. And Ms. Brassetti, how do you know Johnathan Quiles? And what's the relationship between your mother and Mr. Quiles' mother? And Ms. Brassetti, where do you currently reside? And is that where you are currently? Ma'am, you said you've known Mr. Quiles since birth. What have you known about Mr. Quiles as a person? What can you provide to the jury as it relates to Mr. Quiles' background, his upbringing that you were there for? Yeah, any information you want the jury to know about his background and upbringing. Thank you. And what other information would you like the jury to know? So much. Is there anything else that you needed to add or that you wanted to add before we let you go? Thank you so much. Nothing further.
Any questions about the state? Ma'am, thank you for being here today.
Thank you. I'm going to log you off or put you in the waiting room. So you can log off, though.
All right. And Ms. Michelle, you can call your next witness.
Thank you, Judge. I can next call Destiny Quiles.
Ma'am, will you raise your right hand, please?
Her audio is not connected.
She's not connected. Okay. 1 second, Judge.
Maybe you can send her a chat.
Oh, wait, there we are. Can you hear us? Yeah. Right, there we are.
Ma'am, will you raise your right hand, please? You solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you so much. If you could please start by introducing yourself to the jury. And Ms. Quiles, how are you related to Mr. Quiles, Johnathan Quiles? Okay. And I was going to ask, sorry about that. Thank you. And who is your father to Mr. Quiles? Thank you. Ma'am, can you tell us how long you've known Mr. Quiles? And can you tell us what Mr. Quiles means to you? And ma'am, I forgot to ask you this at the beginning, but where do you currently reside? And is that where you are currently? You said your father is Joseph Quiles? Yes. Okay. Can you tell us anything you would like the jury to know about Mr. Quiles in your upbringing and his background? Thank you. Is there anything else you wanted the jury to know or share with the jury at this time? Thank you so much for being here. Nothing further.
State.
Good questions, Your Honor.
Ma'am, good to see you. Thank you for being here today.
Thank you, ma'am. I'm going to move you into the waiting room. You can log off.
All right, defense, you can call your next witness.
Your Honor, if we could next call Donnell Pugh.
Sir, will you raise your right hand, please?
Mr. Pugh, can you hear her?
Yes, sir.
All right, just pay attention to your screen and look at Madam Clerk. She's going to swear you in before your questioning begins.
Will you raise your right hand, please? Do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. If you could please introduce yourself to the jury. Mr. Pugh, where are you currently located? Sir, if you could please provide how you are related to Mr. Quiles. I'm sorry, you said you're his cousin? Okay, have you known him your whole life? Okay. Can you tell us about how your occasions to be around Mr. Quiles? Yeah, how often would you be around Mr. Quiles? Yes, throughout the time that you've known him. And Mr. Pugh, what do you know of Mr. Quiles that you'd like to share with the jury today? What do you know about Mr. Quiles' background that you can share with the jury today? That's all right. What would you like to share with the jury about what Mr. Quiles has been to you in your life? Is there anything else you would like to share with the jury before you go?
No, ma'am.
All right, thank you so much for your time. Nothing further, Judge.
State, any questions?
No, Your Honor.
Sir, thank you for being here today.
Thank you.
You can log off. I'm going to put you in the waiting room so you can log off from there. Judge, that concludes the witnesses that I have on Zoom, and we have one other witness in person, Judge.
Okay, you can call your next witness.
Thank you, Judge. I'm just going to close this out. Is that all right? Or just so that it's not.
If you're done with it, I'm done with it.
Thank you, Judge. Judge, if we can next call Paula Violette. Paulette Violette.
Ma'am, good afternoon to you. Just watch your step as you come forward. You need a glass of water. Let us know. Mr. Gray will certainly help you out in that regard.
Thank you.
That said, Ms. Michelle, you may inquire. You're ready.
Thank you, Your Honor. Ma'am, can you hear me?
Yes.
Okay, great. Thank you. If you could start by just introducing yourself to the jury, please.
My name is Paulette Viduet.
And Ms. Violette, can you please tell us how you know Mr. Johnathan Quiles?
Jonathan is my nephew/son.
And ma'am, you've known him his whole life?
His whole life.
And can you tell me how what the relation is as far as you being his aunt? Who are you related to in his family?
I am his mother's youngest sister, his late mother.
Okay. Ma'am, can you tell us a little bit about Mr. Quiles' relationship with his mom first?
Oh my God. They had such a special bond. He loved her. He was crazy about his mother. He loved everything about his mother. His mother was an amazing woman to him.
What about his relationship with his father?
That was rocky. For a long time, it was rocky. There was a lot of sadness there. But when he got older, he forgave him. They worked on a relationship together, and everything was okay. Nothing further after that. They just mend whatever was broken, and he visited them. He stood with them a couple of months, I believe, and then he went back home.
Okay. As far as their relationship currently, let me start with his mom first. You mentioned his late mother. Mm-hmm. Tell me about when she passed or that situation.
She had cancer.
Okay. And when did she pass?
She passed 13 years ago in December.
And how did Mr. Quiles take that?
Oh, that was really hard for him. Him and his mother were inseparable. He was a caretaker.
I'm so sorry.
I'm sorry.
Go ahead. You were saying
he was a caretaker.
And did they live together during that time period?
I believe he was living with her at her first diagnosis, and then he took care of her, and then later she was supposed to be in remission, so he tried to do his own thing, but she was really never in remission. She was diagnosed incorrectly, so then he had to come back and take care of her.
And then during that time, was he the sole caretaker of his mother when she was ill?
Yes.
Okay. And you said that it was rough after she passed?
It was rough.
During that time period, what was his relationship like with his brother?
I don't know if their relationship was, I want to say was distant. I'll just say that it was distant. I don't remember them being close at that time.
Have you ever known them to be close while growing up?
Not necessarily growing up. I think their closeness came about recently, and I guess maturity brought them back together, and they were able to mend some things and hold on to a good relationship.
Earlier in life, did you know Mr. Quiles and his brother to have like a conflictual type of relationship?
Yes.
Can you tell me about, I guess you told me a little bit about his reconciliation with his father. How do you feel that relationship has affected Mr. Quiles?
John is very forgiving, and when he made the decision to forgive his father, it was pure. And he did forgive him. They worked on a relationship, and like I said, he came and lived with them for a couple of months. And then he went back home. But I don't know if it made up for everything, but it was the beginning of
today.
Well, it was recently before he got arrested. So I'm not sure if they have a relationship right now.
Right. What else can you tell us about John's upbringing, his background?
John had a great upbringing. As you all know, my sister was a single parent. She worked really hard to provide him the things that he needed. She was adamant about education. She had 3 degrees before she passed. He chose not to go to school, and we know why. But there was nothing she wouldn't do for him, or for Joseph, for that matter, for both of her kids. But her and John had a special bond, a really special bond.
And during their upbringing, did John's mother work quite a bit?
She did. Okay. She went to school and she worked.
As far as you mentioned about his education, that he chose not to go, and that was, I'm just using your words. Tell us about what you know of his education.
He did up to the 7th grade. Learning was not a disadvantage for him. He was very smart. He just did not want to go to school. There was nothing that he couldn't do. He comprehended well. He self-educated himself in a lot of things. So it wasn't that, I don't know if he just couldn't handle or he chose to work for his little children that he had at that time, but he was a really brilliant young man at a young age.
And so tell us about his family. You said that he had children at a young age.
He did have children at a young age. He had a boy and a girl. They were back to back. I think they're like a year and a half apart. I believe his first child was born at 15 or 16. And he worked really hard to provide for them.
And as far as his other children that came later, what do you know about his relationship like as a father to them?
He's a great father to them. He's always been a great father to his kids.
And does he maintain, as best he can, a relationship with them to this day?
Yes.
Can you tell us a little bit about you and Mr. Quiles' relationship?
Say that again, I'm sorry.
Your relationship with Mr. Quiles.
We instantly bond at birth. When he was born, he was no longer my sister's child. That was my child. We had a special bond when he was born. I took him everywhere I went. We did everything together. As he got older, I moved. I was married to a military man that traveled a lot, so I wasn't with him as often, but he'd come every duty station we went to spend time with us. When his mother died, I had promised to do my best as a mother figure for him. And when he made the choice to move over here, I was really excited because I would have him all the time. He moved here. He found himself a church home. He gave himself to the Lord. And he enjoyed life. And he's always been a positive person in my life. I've never seen him handle things in a negative way. There's never a moment if I'm sad or I'm down. He always say things to just lift me up. And he did that for his mother. Even though his mother's cancer was incurable, he always kept her spirits high.
What do you know about Mr. Quiles' work history and kind of his background, employment background?
Mr. Quiles can do anything he put his mind to. He can work on cars. He can be a carpenter. He can be a mechanic. There's nothing that he could not teach himself to do. And he always had work. He can find work easily because he was so skillful.
Can you tell us a little bit about what your relationship has been like and what you know of him since he's been incarcerated?
Even being here for 5 years, I've never seen him sad. I've never seen him cry. He's always so uplifting. I'm the crybaby. I'll cry on the phone with him. I'm sad, I'm upset, I'm angry. And he's like, Mom, it's going to be okay. I promise you it's going to be okay. And he never loses hope, ever.
Can you tell us a little bit about, I know you have kids, correct?
I do. I have 4.
From a few of them today.
Yes.
All right. Can you tell us a little bit about the family dynamics as far as your family and with Mr. Quiles?
Yes. John always says he's the firstborn, so he makes my children really jealous. So he'll say, that's my mom. No, that's my mom. I'm the firstborn. You know, silly things like that. But they all get along as if they were all natural brothers. They all get along. He impacted my 2 younger kids. He taught them a lot of stuff. My youngest son couldn't ride his bike for years. And John came one time, and my son's never stopped riding his bike. But no one could teach him how to ride his bike but John. So he's impacted my children in such a positive way. He was their go-to person. He would build go-karts and teach them how to ride the go-karts, showing them what angles to turn, what not to do, just a lot of fun stuff. And he would educate them that education is the most important thing.
Can you share us a little bit about what Mr. Quiles means to you personally?
He's my everything. He's my light at the end of the tunnel. I go to him for everything. He always has special words for me. He always tells me, no matter what I'm going through, God is going to see me through everything. There's nothing that I can't overcome. And I look forward to hearing his voice every day. He is my connection to my late sister. My sister and him have a special bond, and I see that through him all the time. And when I see him, I see my sister. And I look forward to speaking to him every day, every opportunity that I get.
Can you tell us any other information you would like to provide to the jury today before we let you go?
Yes. I just wish everybody knew John like I knew John. John is such a warm, loving person. Everybody that comes across John have a special bond with him. He just has a natural love for people. And I just wish everybody was able to see that in him, because he's an amazing young man.
Could I have just a moment? The questions, Your Honor.
Ma'am, good to see you today. Thank you for your testimony. Defense, any additional witnesses?
No, Your Honor. That's what he has.
All right, members of the jury, give me 15 minutes. I need to finalize some instructions with the attorneys, and then we'll go to closing arguments. It's no secret at this point, after closing arguments, I'll be able to dismiss the 4 alternate jurors. That's not a secret I can keep anymore. I'll see you back at 2:35-ish, and we'll go from there. Please remember, don't discuss the case among yourselves or each other, and we'll go from there. Oh, I'm sorry. Hold on one second. I failed to let you know this. So when we go to the closing argument phase, the first 12 that are serving, that's when we got to take your devices from you. So if you need to contact loved ones, let them know. Just like as I told you last Thursday, we will be here as long as you guys want us to be here tonight to deliberate. We don't know when that decision will come. If you want to break when it come back tomorrow morning, like we talked about Thursday, we will do that as well. I'll give you further instructions. I'm mostly letting you know that if you have to contact a spouse, family, friend, whoever, to let them know you may be out of pocket for a while tonight, this is probably the chance for you to do so. The jury's outside our presence. I still have counsel of state defense, Mr. Quiles, present. I want to finalize these jury instructions. So, Ms. Michelle, I did look at 10, 16, 23, and 28 that you mentioned. They all do seem to be redundant. I tend to agree with you. I kind of did a keyword search, and the other things that are mentioned in those 4 circumstances are also mentioned otherwise. So, if you guys are okay with that, I'll delete those 4 aggravating factors off the final jury instructions. And just for the record's clear, the defense agrees what I'm deleting is already encompassed in the other mitigating circumstances alleged in the instructions.
That's why we suggested those to the court to be removed, because we do see them in other ones, and they are overlapping to other ones as well. So, yes, we agree.
Okay, so they are deleted. Other than that, the jury instructions seem to be in rather fine form. I do have in jury instruction, the verdict forms as well. I can go upstairs and I'll print copies of everything. Is there anything that either party wants to add regarding the instructions? Any objection to how the aggravating factors are listed, mitigating circumstances, or the additional instructions of how I phrase it for weighing the evidence, rules for deliberation, verdict, and to submit the case to the jury?
Acceptable to the state, Your Honor.
And while the defense is looking at that, I noticed that you guys didn't call Joseph Quiles. I'm assuming that was a decision the defense made.
Yeah, he was having trouble getting on, and so instead of trying to wait and figure that out, Judge, we did not call him. We made that decision, yes, Judge.
Is he able to get on at all?
I know that when I asked them, I had already told them, they said that it was fine not to call him, so we will not be calling him, Judge.
When you said they, who's they?
The family that have been in contact with him to try and see if he would be getting onto Zoom.
Okay.
And we did discuss that with our client.
Okay.
We did let him know, and that's fine.
All right. And obviously, Mr. Quiles didn't testify in this penalty phase, just like he didn't do in the guilt phase. I don't see the necessity to inquire again of him in that regard, unless the defense thinks that's necessary. Obviously, if we, depending on what the next steps are, he always has a chance to address the sentence in court at the appropriate time, if that's what he decides to do.
Yes, Judge, that's fine. He knows he's not testifying, obviously, now, but we've discussed the option later with him as well. We don't expect that to be the case, but
so he's agreeing not to testify at this phase as well.
correct.
Okay, and you guys have talked to him about all that?
Yes, we have, Judge.
Okay, you've answered all his questions?
Yes, Judge.
Okay. So I'll let you look at the verdict for, I'm sorry, go ahead, talk to your client if you need to.
Yes, Judge. I'm going to let Mr. Davis address the one issue that we had with the instructions, which may not be one at all, and then I'll find out what he wants to know. Judge, and just affirming everything that I just said as far as testimony and specifically about not calling his brother, just making sure that all of that was as I represented to the court.
And he's in agreement with that?
He is.
Okay. All right, we'll move forward with the jury instructions. Are there any objections to any of it from the defense at this point?
No, Your Honor. We were just looking at one other thing, but for now, there's nothing else to add.
So in total, you guys are in agreement with the jury instructions as prepared and as will be read to the jury verbatim. Otherwise, I know you raised an objection to the 6th aggravating factor regarding familiar or custodial relationship.
Correct. And there was one other that we had discussed, but at this point, Judge, we don't have any other objections other than the ones that have already been raised.
Well, do you want to raise the thing that you guys are discussing so I'm aware of it?
Well, Judge, just in going over some of the things, just for purposes of the record, we would renew all our previous objections and arguments without any further argument, just to preserve those for purposes of the record, Your Honor. That's number one. Number two, we're looking into, brought to our attention, requesting for a mercy instruction, and I'm looking for it. I don't know as though I'm able to do so.
The standard instructions talk about that. If you, it's on page 8 of 15.
Right, and I was looking to see if there was anything else that can be expanded upon that. That's what I was looking for specifically, to see if there's any additional language that under the jury instructions or the rules that could be added, and that's what I was looking for.
Okay. I mean, it is included in here. It may not be as explicit as the defense request. These were just amended, I think, earlier this month.
Exactly.
Nothing stops you from arguing that, though, based off the law that I'm reading to the jury.
Right, and that's what we were looking for, just to make sure that we cover all our bases on that, Judge.
Okay. But nothing you're proposing at this point.
Nothing that I think we can propose that isn't already there.
Okay. And how about the verdict forms for count 1 and for count 2?
I'm sorry. We didn't see anything to object on that, Your Honor.
The only difference is, I think, in count 1, I have the HAC, the aggravating factor. Count 2 does not. Count 2 has the victim was less than 12. Count 1 does not. And both have the last aggravating factor. The victim was particularly vulnerable for 2 different reasons. So there's 5 aggravating factors alleged as to each victim. What I'll do is I'll go upstairs, I'll print everything, I'll come back out, and we can commence closing arguments unless there's something else from the attorneys that I need to handle.
Not from the defense?
Not from the state, Your Honor.
Okay, give me 5 minutes, I'll come back out.
Sir, Your Honor.
All right, let's go back on the record. 19 CF 7518. I have counsel of state defense, Mr. Quiles, present. So I have copies of the verdict forms for counts 1 and 2, 3 pages each, and then jury instructions. Anything else we need to handle before we bring the jury in? First from the state. Defense. All right, let's bring the jury back in, please.
Your Honor, the jury's re-entering the court.
Members of the jury, welcome back. You guys may have a seat, of course. Members of the jury, both the state and the defense have now rested their respective cases for this phase. The attorneys will now present their final arguments to you. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. State, you have the floor.
May it please the court.
Yes, sir.
Ladies and gentlemen. We are endowed by our Creator with certain unalienable rights, and that among those are life, liberty, and the pursuit of happiness. We are a nation of laws. Thomas Jefferson wrote those words in 1776. He was in an upstairs bedroom at the corner of Market and 7th Streets in Philadelphia, Pennsylvania. Those words are so powerful. It's the foundational principle of what this great country stands for. That foundational principle would later give us the United States Constitution. All premised on that each and every one of us have those unalienable rights. Our courts are supposed to preside over disagreements when a violation of those rights occur. Legislatures are supposed to pass laws to protect those rights. The executive branch is supposed to enforce those laws when they are broken. Those words that resonated so loudly in the Declaration of Independence still resonate today. Why? Because this foundational principle has existed forever. Since 1776, 248 years ago. All of us have a right to live. All of us have a right to liberty, to freedom. And we have them because they were endowed to us by our Creator. Have you ever chewed on the word unalienable? What that means? It means they're impossible to take away from us. They're not capable of being denied to us. They should not be denied to anyone because they're that foundational in what we all believe and stand for. The defendant stripped each and every one of those from Iyana and from Hazel. He now forfeits his right to life as he knew it. He now forfeits his right to pursue happiness. He now forfeits his liberty. But what should his sentence be? Should it be life in prison without the possibility of parole? Or should it be death? The defendant took the freedom of a 16-year-old young girl and an unborn baby. He took their pursuit of happiness. He stripped them of their ability to ever pursue happiness again. He took away IS's motherhood. He took away that unborn baby's daughterhood. IS lived the last seconds, minutes, or hours of her life at some point as her life was about to draw to a close with something that was about to happen to her that was atrocious, and it was cruel, and it was heinous. Even the defendant said he couldn't stomach it. IS would never go to school again. She'd never read that book again, any book. She'd never work at Chick-fil-A again. She'd never visit a neighbor across the street again. And the list goes on. Why? Because the defendant snuffed out her life. Because he himself, with his selfish interest that even his own doctor said, he's self-centered. He chose to kill two humans because he may wind up in jail sitting right next to those people he was talking to on the wire. He carried out a heightened premeditated plan. We'll talk about CCP in a bit. He did everything he could to get away with it. He tried to stay off cameras. He worked really hard to dump that body using bags or blanket, doesn't matter which. He somehow got her in that dumpster. He got rid of her book bag and her other bag and her underwear, and he got rid of her. He turned off his geolocation data. All this is going to go to what's called the cold, calculated, and premeditated aggravating factor. He deleted stuff off of his phone. He takes a gun with him to work. He went and got it out of wherever he had it in his home, and he put it in his red minivan. Drove it to work that day. Cold, calculated, premeditated. And he goes and shoots at the gun range that afternoon on the 20th to blow off steam. All while IS and her unborn baby lay in a landfill somewhere. And then 22 days later, he's laughing it up in jail with two guys saying she's cooking out there. Cold, calculated premeditated. Even he himself on that wire says this is a premeditated murder. Well, all that, ladies and gentlemen, begs the question, what is justice? This case is about to be yours, or the people, the most powerful entity in this great republic that we have. People get to make the decision. Now you get to decide what to recommend to Judge Salem and hand him your recommendation. You get to do that. Now you heard all the aggravating factors. If you notice in the penalty phase, here we didn't put any facts because you heard them all. And I'm going to walk through them in just a few minutes, but aggravating factors, quite frankly, ladies and gentlemen, think about the definition of them. The court's going to read the exact definition by Florida law of an aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim that's inherent in all first-degree murder cases. It's higher than all other first-degree murder cases when those factors exist. There are 6 of them in this case. 5 of which apply to each respective victim. As we walk through those, I'll explain that. The defense, as you now have seen, presented mitigating circumstances to you. And when you go through this process, you get to weigh those, so long as we've proven at least one. That's all it takes for you to move on to step 2. There are 2 major steps here. Did the state prove one aggravating factor to you beyond a reasonable doubt? And did they do so where you voted unanimously? We argue to you that all 6 have been proven to you beyond a reasonable doubt. Some based on your verdict. We'll talk about that. And then once you make that determination, you move on to the second step, which is, are the aggravating factors that you determine to be proven sufficient in of themselves to warrant the imposition of the death penalty? And once you answer yes and that answer affirmative to that question, you move on to that weighing that we spent a lot of time in jury selection talking about. And we ask you, can you meaningfully consider the mitigating circumstances that the defense presents to you? And you have to. You have to. That's why you're here. You went through an enduring process of questioning, and you will follow the law because you've taken an oath that you will. We are a nation of laws. And you'll make this decision not because it's easy, it's not, it's hard, but because it's right and it's just. And it is justice, and we'll talk about why in my argument to you. When you go back and deliberate this decision, base your decision on the law. Base your decision on the aggravating factors. Don't pull anything else in it. That victim impact testimony was extremely difficult, and we know that for you to listen to. Please, as the court made very clear, you cannot call that an aggravating factor. The law doesn't permit it. So please take only the 6 that we articulate for you and conduct your weighing with only those aggravating factors. If we are going to uphold the principle that Thomas Jefferson spoke about, that we all have those unalienable rights, they've been given to us by our Creator, what do we do when someone else, the defendant, takes those away? That is your question. What does justice look like? And the answer, quite frankly, ladies and gentlemen, is this. The defendant must be held accountable for his actions. He must be. We are a nation of laws. No matter whether you agree with who sits in the presidential office, some powerful words have come out of that office for the last 248 years. A modern-day president said this:
"We must reject the idea that every time a law is broken, that society is guilty rather than the lawbreaker. It is time to restore the American precept that each individual is accountable for his actions."
The question is, will you hold him fully accountable? Not partially accountable, fully accountable. While the three branches of government have done their job, ultimately we are handing this case to you as the executive branch and handing it to you and saying, hold the defendant accountable for taking away IS's rights and their liberties, and her unborn baby's rights and her liberties. The real power does lie with you. When someone's life is taken, when someone's liberty is taken, when someone's pursuit of happiness is taken, we must address it and we must respond accordingly. Please note that the court will also instruct you when he gives the final instructions in just a little while. He's going to say to you, this is not a numbers game. It's a weighing process. So while it's easy to say, well, you're going to look at their list of mitigating circumstances, they'll talk to you about it. There's upwards of 20-something, upper 20s. It's not, well, who has more? Okay, so please make sure that is not part of your process. The court will talk to you about that. He'll talk to you about the weighing, the deliberative process that you must engage in. And it's simply this: did we prove to you at least one aggravating factor beyond a reasonable doubt? And you have to find that unanimously. Now, if you believe that of the 6 that we're going to present to you, that 4 of you were proven unanimously by you, that's the 4 you take with you and conduct that weighing process. It's the proven ones. We believe we've proven all 6 to you. We'll talk about them in a minute. You take what you believe has been proven unanimously. This is your decision. Power is with the people now to follow the law. Why? Why must you follow the law? Because we are a nation of laws. Ladies and gentlemen, I argue to you this is the very definition of aggravated murder. It is. You convicted him of first-degree murder with premeditation when you found with your verdicts on count 1 and 2. Now your role in accomplishing justice is about to be completed with your recommendation that you're going to hand to the court. Well, what are these aggravators? Here's the first one. Let's take a look at your screens. The defendant was previously convicted of another capital felony or a felony involving the use or threat of violence to another person. Note right underneath that, the crime of sexual battery is a felony involving the use or threat of violence to another person. You found that. You found that unanimously on Friday in count 3. That was previously, and that counts for purposes of this aggravating factor. There's the law in front of you. That's aggravating factor number 1. That's already been proven to you unanimously. That you've already found beyond a reasonable doubt. Now you just tally up your aggravating factors and go on to that second phase. That alone, with your verdict, in that verdict form, when you check the box for count 3, accomplished that aggravating factor. It's proven. Not because I say so, because you said so. And that was your verdict. And the state thanks you for that verdict. But that alone gives you aggravating factor number 1. Now, you can view that aggravating factor as to both counts. As to count 1, you can look at counts 2 and 3 and say not only did you convict him of first-degree murder, but you convicted him of first-degree murder of the unborn baby, and take either one of those, count 2 or 3, and apply it to this aggravator, and it becomes more weighty. That's key here. It becomes more weighty.
As to count 2, first-degree murder of the unborn child, you can take counts 1 and 3 and bring them into your calculus with respect to this aggravating factor, and that also becomes weighty. As to both counts, you'll make a decision as to both. The imposition of life in prison without possibility of parole, or the imposition of the death penalty. You'll do that for both counts, count 1 and count 2. The question that you have is, how heavy are those? In the previous a felony involving the use or threat of violence to another person, you already found it twice. And that's a weighty aggravator. The second aggravating factor is that the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody. Obviously, this is with respect to a lawful arrest. Ladies and gentlemen, that was what the entire trial was about. When little IS at age 15 became pregnant on July 7, 2018, confirmed on December 13, 2018, by Dr. Atchu, you saw those series of painful Snapchats of what he was putting her through. The mental twisting about having this baby. I don't even know how I got you pregnant. I've been kicked down there so much. You remember that one? He did this for one selfish reason. He didn't want to go to jail for it. That's eerily similar to what we just heard today from a doctor. He's egotistical. He's self-centered. He's narcissistic, she said. And this aggravating factor heightens it. It increases the gravity of this crime or the harm to a victim because he's choosing something selfish to stay out of jail in exchange for taking away human life times 2. It's the whole motive. Quite frankly, with your verdicts, you found him guilty of premeditated murder. This is inherent in that. How? It's the whole entire motive of the case, which we showed you repeatedly, not only with those Snapchats, but that wire. If that baby had been born, I'd be in here sitting right next to y'all. It was a chilling statement, ladies and gentlemen. That was a chilling statement. In essence, if I kill them, he's saying, I won't be arrested. And that's why this aggravating factor is weighty. That's why you will find it beyond a reasonable doubt. And that's why you'll use it also in your weighing process. Now, this aggravating factor applies to both counts 1 and 2. Why? Baby Hazel is who he wanted to die so he wouldn't be arrested. If that baby's born, I'll be sitting right here with y'all. He had to kill IS because she was going to have the baby. So the aggravating factor applies to both. And it's weighty. And you get to weigh them. You know, listen, when you get to the mitigating circumstances and kind of conduct that weighing, you can call them wafer thin and light as you can tag them. You heard some mitigation today. I'm not going to spend a lot of time walking through that, but you heard a lot of mitigation. Well, he didn't really get along with his father. You can attach very little weight to that when you pile these up. You can stack those mitigating circumstances to the moon. And they do not outweigh these aggravating factors. And we're only at 2 of 6. Now, third, this one has a lot of instruction to it. This is called the especially heinous, atrocious, and cruel aggravating factor. And Judge Salem will define it in detail for you. You're going to hear the words. Now, this aggravating factor only applies to IS. Why? Because this is who he said he strangled. You can't strangle the unborn baby, so we're not going to argue before you that this aggravating factor applies to Hazel, but it certainly applies to IS. Why? He chose to strangle her first.
Listen very, very carefully here, ladies. Listen to the definition of this. Heinous means extremely wicked, shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, and cruel is one accompanied by additional acts that show the crime was conscienceless or pitiless or was unnecessarily torturous to IS. Think about this, ladies and gentlemen. He somehow gets a 15, now 16-year-old girl to lure her to his work. He gets her in an area where nobody can see them, off camera, with a gun in tow. And he reaches up and starts to strangle her. While she's alive. His own brother on the witness stand said, well, yeah, he called me back and said, he was frantic, he was panicked, he didn't know what to do. Called me back and says, it's been taken care of. What that tells us makes this aggravating factor proven. Why? Because she's alive when he placed his hands around her, and as he described it, he couldn't stomach it. Is it shockingly evil and extremely wicked to strangle a teenage child and then shoot her to death? Yes. Is it outrageously wicked and vile to treat a human being who's carrying what he thought was his baby like this and attack her like this in an industrial lot in the middle of the day when she should be at school carrying his child? Yes. Pretending like he wanted to take her out of town or run off with her. The poor little girl had underwear packed. And when she gets there off to the side, his hands or whatever, he tries to strangle her, goes around her neck. That's what he said. I'm not even arguing that to you. That's what he said. And oh, by the way, has his gun with him, knowing full well that she can't be gone long. Not in that family. Not with those 5 aunts who are wonderful people. And all they do is just, everybody knows everybody else what's going on. There's no way she's going to run off for any period of time, not be missed. We had to do it quickly. We planned it a while. That's the next aggravator, CCP. We'll talk about that in a minute. But as to heinous, atrocious, and cruel, it was clear from the brother that he strangled her first. Do you think he did these things to her with utter indifference? Well, I'll say this. When he referenced to his brother, he couldn't stomach it. He sure is laughing about it in the jail 22, 23, 24 days later. Indifference? You bet. A man capable of killing who he believes is carrying his child, and he couldn't stomach it. To strangle and then bring a gun to work, there's one purpose for a firearm, especially at that job on that day, and that was to kill her. And he tried a certain way, and it didn't work. Shot her. And that's what he said. Could have pulled his gun out and just shot her. That's not what he did. That's why that aggravating factor is before you. Pitiless and simply cruel. Now the next one, that's 3 aggravating factors, folks, that we argue those have been proven to you beyond a reasonable doubt. Here's the 4th one. Cold, calculated, and premeditated manner. The first-degree murder was committed in a cold,
calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. Drop to that second paragraph. You know the first paragraph. You remember that from your guilt phase instruction. Look at the second paragraph. In order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. He lures her away from school. He coordinates a ride somehow for her. He gets his gun in advance. He takes his gun from his home and puts it in his pants or truck or his minivan. He drives it to work. He has a plan to get rid of her clothes, her books, her belongings, to get rid of her body, somehow to lure her from Terry Parker High School. He has the dumpster picked out because it normally gets picked up on Tuesdays or Wednesday. Much of this he's saying on the tape. He picks an area where it can't be seen on camera. He picks an area where his wife won't see that he's somewhere unusual, like way out in the woods on the north side or the west side. He picks an area that is off camera. He tells Iyana something, we're going to run away, or whatever it is he told her, to get her phone turned off, to hide that from the family. He turns off his geolocation data and then blends right in after he does his deed at work. That's why this is cold. It's calculated. It's premeditated. Listen to what he says on the tape. Man, were y'all fixing to run away? Yeah. Were you faking it? And the defendant goes, yeah. That's a plan. As his brother said. He told me he'd been planning it for months. If you read that second paragraph, that's all you need, folks. This aggravating factor, 4 of them have been proven beyond reasonable doubt. This is heightened, calculated premeditation. Heightened premeditation. On the wire, you knew it was your baby. Well, I wasn't 100%, but you don't want to take that chance, said the inmate. Here's the defendant's response. It's all about the baby. He wanted her and the baby dead. On the wire. I won't say the word. You've been effing her for how long? About a year, he said. You know when she got pregnant. Even the defendant, they ask, oh, what do you think will happen? You think you'll get the needle? You know what he says? Yeah, this is premeditated. That's what he said. The only conclusion from the evidence in this case is that he wanted them both dead. This aggravating factor applies to both. Count 1 and count 2. You can take this aggravating factor, you can pack it up and bring it to step 2 of your analysis because it's been proven beyond and to the exclusion of every reasonable doubt, and you should find so unanimously so that you can weigh it. This is the very definition. This fact is the very definition of heightened level of premeditation. The 5th, this is real simple. The unborn child of IS, Hazel, that is her name, was a person less than 12 years of age. I don't need to insult your intelligence. That's been proven beyond a reasonable doubt. That you should find unanimously. Now we're up to 5 that you can put in the hopper and weigh against that mitigating circumstances that were presented to you today. And the last aggravating factor. IS, Iyana, and the unborn child, Hazel, were particularly vulnerable because the defendant stood in a position of familial or custodial authority over IS or the baby. Folks, that's her uncle. He believed to be the father of that baby. He believed the baby was his. It's why we're even here. IS is over at the aunt's house, his wife's house a lot. She's over there sometimes alone. Naomi took the witness stand and said, oh yeah,
once a month or a couple times a month. It's kind of an as-needed thing. She came over a lot. The nieces did a lot. Did they come alone? Yes. He made everybody dinner, and then he would give IS her own special dinner, as we heard, making them food. She'd be gone. Naomi would be gone out in her trucking job until like 2 in the morning. The defendant taught IS how to drive. He took her to the beach. He taught her how to swim against the current. He picked them up and dropped them off at school. There is no question he is in a custodial. He's 33 years old. Over this 15-year-old girl's life in his home. Carrying a secret that that's what he believes to be his child. This most certainly is custodial authority. Not only as to IS, but that baby, he believes it's his. If anything on earth he should be protective over is who he thinks is his baby. That's why this is also an aggravating factor. And it should be weighty to you. Now, once you go through these aggravating factors, if you believe not all 6 have been proven, you can take 4 or 5 of them, still stick them on the hopper. Now, some, as you just heard, one of those does not apply to IS, one of those does not apply to unborn babies. So technically 5 you're weighing against each particular count. You have 6 in total, and that's what you're going to use in your calculus. Think about it this way, ladies and gentlemen. As you evaluate these, and as you weigh these, and as you attach weight to them, think about this. The defendant lured her to her death. The cold, calculated, premeditated plan. He lured her away. She had packed up underwear, and he packed up his gun. When she strolled out of Terry Parker High School on the phone, as you saw with your own eyes, he's in a few minutes going to turn his geolocation data off. Goes right to cold, calculated, and premeditated. Somehow she makes her way out to Ace. What's he doing? Getting bags or a blanket ready. It's cold. It's calculated. It's premeditated. While this little girl is living a confused life, trying to decide whether to have the baby, she eventually did decide whether to have the baby. They were going to have the baby. He, for months, is planning to kill her. That's cold. That's calculated. That's premeditated. In a heightened manner. He had so much time to reflect and just say, no, I'm not going to do it. But he did. But he did. While she made her way to him from Terry Parker High School to Ace that day, he's making plans how to get rid of everything. Cold, calculated, premeditated. As that all-American garbage truck carried her off to her grave, he's calling his brother, telling him he took care of it. That's cold. That's calculated. And 22 days later, as she's cooking in that landfill, he's laughing it up on the wire, confessing with his own mouth. Still trying to figure out a way to keep the authorities from finding her, planning in the jail. Hey, maybe I got someone on the outside. Go over there and move her. Remember that? Now that's cold, and that's calculated, and that's premeditated, and that's heightened CCP. Will you hold them accountable fully? Or will you hold them partially accountable? Now, you heard a lot about mitigation today. I'm not going to spend any time talking to you about it. But ladies and gentlemen, whether he fixes cars or helps a
cousin, whether he makes go-karts for nephews, whether he encourages somebody to go to school, that does not outweigh. You can stack them all up. And you only have to find those by a greater weight of the evidence. Not on the state standard, and it should be. We have to prove these beyond a reasonable doubt. You only have to find those by a greater weight of the evidence. You can, just presuming for a minute you find every one of those, you can stack them up on one side. They don't even come close to the weight of these six. Not even close. 6. 5 as to each victim. Paul Johnson, one of the most famous authors, great historian too, he wrote this about America, quote, "This is the greatest of all human adventures." End quote. And he said that, and he's right because of our government structure. And our government structure is so right, and everything works. We have these 3 branches of government because all the way back to when Thomas Jefferson said those words and made us a nation of laws is one of the reasons why we're sitting here today. You must be held accountable when you break those laws. Freedom comes with responsibility. The defendant had his unalienable rights. He's forfeited them. You found him guilty. One of those many responsibilities that we have as Americans, from paying those dadgum taxes to getting our licenses or paying your property tax bill, one of those responsibilities is don't hurt anyone else. Well, the defendant killed 2 people. He didn't just kill 2 people, he killed a niece. He killed a niece that he impregnated, he thought. And when you do these kind of things, you must be held accountable. That's what the criminal justice system is for. That's why we've done what we've done these last 2 weeks and a day, and we're handing this over to you. Now it is your turn to hold him fully accountable. Partial justice is partial accountability. Full, complete justice is full accountability. And if you really think, as I close, think about this. Justice is everywhere. We all strive for that. These systems that we sit in today, that you're getting to watch the judiciary and the executive branch and the law with the legislative branch, you've watched it at work. And think about this. Justice is mentioned everywhere you go. I visited New York City recently, and in Theodore Roosevelt's childhood home, this famous quote he said is on the wall. The fundamental need in dealing with Americans, our people, whether laboring men or others, is justice. Right off the National Mall in Washington, D.C., you can go walk up and look at a Dwight D. Eisenhower monument, and plastered on stone is the following quote. "We look upon this shaken earth and we declare our firm and fixed purpose, the building of peace with justice in a world where moral law prevails." You can walk just another mile and look up at the United States Supreme Court, and it says, "Equal justice under law." I started by quoting Thomas Jefferson for you. Listen to what Thomas Jefferson said about justice. Quote, "The most sacred duties of a government is to do justice to all its citizens." Will you do justice? These verdicts that you handed down on Friday, coupled with these aggravating factors, cry out for justice. Bring the court back a recommendation to impose the death penalty for both count 1 and count 2 against the defendant. Because after reflection, after thought, you will see that these aggravating factors have been proven beyond a reasonable doubt. You will see that they outweigh every mitigating circumstances the defense is going to talk to you about.
and then justice will be closer to being completed. Iyana and Hazel are gone. Their liberty is gone. Their pursuit of their happiness ended on December 19, 2018. The justice for her and her baby continues to this day. Complete justice for Iyana and for her unborn baby. Impose the death penalty on this defendant for killing these two human beings. Thank you.
Counsel for the state defense, can I see you at sidebar on a quick
Yes, sir.
issue real quick? Members of the jury, feel free to stand up and stretch if you would like.
Good afternoon again. Thank you so much for your time. Thank you for your attention today. Thank you for coming back after the weekend. Appreciate that. What you heard today echoed from several people about the person that Johnathan Quiles was and has been to his family. You didn't just hear today about the type of person that he has been. You heard about it throughout the last couple of weeks as well. And something that was said today a couple of times is that something redeemable there with Johnathan Quiles. You've heard about the aggravating factors from the state. I'm going to go through a few of those with you. Not all of them. Some of them we're not going to make any strong arguments to. I'm not going to insult your intelligence, as Mr. Skinner said. IS's unborn child was obviously less than 12 years. I'm not going to stand here and argue about that. But I do want to go through some of those because what you must do for each of those aggravating factors is you must unanimously find that each has been proven beyond and to the exclusion of every reasonable doubt. So I just want to bring to your attention a few things that we believe the state has failed to prove. As we talk about prior or previously convicted, we're talking about the crimes that you all just found him guilty of. We're We're not talking about some extensive or prior criminal history before this. We're talking about these crimes here today and only these crimes that you all found him guilty of. There's nothing previously from that. The second factor that they talked to you about had to do with the purpose of avoiding or preventing a lawful arrest. And I ask you, has that been proven beyond and to the exclusion of every reasonable doubt? That was the purpose behind what you have found him guilty of doing? If you do not feel that that is the case, if there's any doubt to that, any reasonable doubt to that for you, that is not an aggravating factor that you can put into that pile and start weighing, as Mr. Skinner used that analogy several times. The comments that were made later on are being used to inform about maybe what his mindset was at that time. But there's reasonable doubt as to those comments, what the truthfulness of those really were. I want to move on to the heinous, atrocious, and cruel, HAC as we sometimes call it. And it's kind of coupled with the cold, calculated, and premeditated aggravating factor as well. It's hard to have both. You can't have it both ways. And by that I mean, you can't say, oh, I couldn't stomach strangulating someone, and it's cold and calculated. You can't say that that at the same time goes in the same bucket. Those contradict each other, and the facts and the things that you all found, the testimony and the things that you heard on the wire, contradict some of this. So I want to go through a few things with you. On the wire, the thing that you heard was him confessing to shooting IS. That's what you heard. He never once in that wire talked about strangulation. A shooting death generally is not included in that heinous, atrocious, and cruel aggravating factor category. Doesn't mean that shooting death is not a terrible thing, so don't get me wrong. That's not typically what they're talking about. We're talking about something worse than that, something where that victim was in a torturous type of circumstance. And a shooting death is typically not that type. The thing that you heard is actually from Damian Hatch. That's the person who said that there was a strangulation and he couldn't stomach it. And that testimony, we believe, has been proven to not be the truth. So if you're thinking back to what was said and what was brought up, I would stress to you all to think back to that testimony and what you actually heard. Reasonable doubt exists as to that aggravating factor. You talk about the statement of couldn't stomach it. That's not conscienceless. That means there was some conscience there. There was something there that said, that's not right. I can't do that. And it's such a crazy thing to stand up here and argue and talk about strangulation versus shooting death, which one was worser, and that type of which one's worse or not. Such a strange thing to stand up here and say. But the strangulation part is the part that would rise this particular crime to the level of heinous, atrocious, or cruel. And so when you're thinking through that, if there's doubt there, if there's reasonable doubt there, that is not an aggravating factor that you can bring on to that next section. We're not arguing that there isn't at least one. I'm not making that argument. So when I'm talking to you about these factors, it has to go to what you're weighing in the end as you learn or think about these aggravating factors versus those mitigating circumstances. Let me talk to you about the CCP, cold, calculated, and premeditated. Cold, calculated, and premeditated. Ms. French told you in her opening, that's the one they have to prove all of those. It's not or. You must be convinced beyond a reasonable doubt that each of those existed. And what we submit to you provides reasonable doubt for that particular factor. What did you hear from his brother? His brother told you that he called him in a panic, that he called him frantically, not knowing what to do. This is the day that this murder is alleged to have happened. That's not evidence of a months-long plan. That's someone who didn't know what they were doing. And specifically for the cold, that particular definition that you're going to be read from the judge talks about cool and calm reflection. And specifically, it's not an act that's prompted by emotional frenzy, panic, or fit of rage. We would submit to you that the evidence you've heard is that he was in a panic, that he was frenzied. That negates the cold portion of that aggravating factor. And if you don't have each of those, you cannot bring that aggravating factor into your weighing process. The sixth one, the fifth one has to do with the unborn child being less than 12. So I'm not going to talk about that one. The sixth factor that they talked to you about has to do with being in the familial or custodial relationship. You've already found that Mr. Quiles was in a familial or custodial relationship as it relates to IS. That was found within your sexual battery finding. I'm not arguing that. What hasn't been found, nor has it been proven beyond a reasonable doubt, beyond and to the exclusion of every reasonable doubt, is that he was the father of IS's unborn child. He didn't even know. If you take every word that he said it was a possibility, but he didn't even know that. So has that been proven, that he's in a familial or custodial authority over the unborn child? If there's doubt to that, which I would submit to you, that will be doubt, then you can't bring that into your weighing as it relates to the unborn child. Mr. Skinner talked to you a lot about being held accountable for your actions. I want you to think back to jury selection. Seems like a lifetime ago. It's 2 whole weeks ago. 2 weeks ago we started. I asked each and every one of you if you believed that life without the possibility of parole, in the worst case you could imagine, if that was a sufficient punishment. I asked each and every one of you that. You all agreed to that you did believe that life without the possibility of parole was a sufficient punishment in the worst of cases that you could possibly think of. So when we talk about fully or partially accountable, life without possibility of parole is being held accountable fully for your actions. There's no partial there. I asked you during jury selection if you'd be able to meaningfully consider the mitigating circumstances that will be presented to you. I told you that those mitigating circumstances could come from anything. It could be something that we presented like we did today, witnesses that you heard from. It could be something that you heard throughout the trial. It could even be something that the state has said. It could be anything that you've heard, anything that you've observed. And if you recall, when we were talking about those mitigating circumstances, I told you all that it was a very individual assessment a moral judgment by each of you that you would have to make as to each mitigating circumstance that you find any weight to. And we have to prove those to you by a greater weight of the evidence, and I would submit to you that we've done that for each of the mitigating circumstances that I'm going to go through with you all. I want to talk to you about some of the things that we didn't present here today and just remind you of them from what you heard throughout the trial. You heard from Johnathan Lindros, and you heard from Gary Lindros. They talked to you about the type of worker, type of employee that Mr. Quiles was during his time with them. He wasn't with them for very long, only a few months. But he excelled. He did his job well. They said he did his excellence. He went above and beyond. He was a model employee. That has been proven by a greater weight of the evidence. You've heard that from multiple people. You've heard several other witnesses say the same thing about him, not just in his as an employee, but just in general of how he is and the type of person that he's always been. He's a hard worker. He's someone who will go out of his way to help people. You heard anecdotal evidence of him building stuff at a church, a sound booth, or the band area. You heard other people talk about him helping them out with several projects and things like that around the house, coming up with things. If he didn't know how to do it, he'd figure out how to do it to help out. But that was the type of person he always has been. You heard from Ulysses Dixon. He was the gentleman who came in, who led the Bible study. He told you about the things that he's observed of Mr. Quiles since he's been incarcerated for these last almost 5 years. He talked about how I think he said he clipped toenails for some of the elderly, that he helps out other people. You heard that echoed by Dr. Rohrer today. That's been reported by several people, that he was helping the elderly, helping those who are more vulnerable. The other things that you've heard about his background since he's been incarcerated, that he's been a model inmate. He's got no disciplinary reports whatsoever in nearly 5 years. And not only that, Dr. Rohrer told you that she was shocked to find out, surprised to learn, that he was allowed to be an alternate trustee, to go and clean the jail, and did that to excellence. He didn't have any issues, was entrusted with that. Why is that so important? Why would we be bringing that up to you? Why is clipping toenails for the elderly something that you would care about? Because it demonstrates that there's something redeemable there. There's something good that he could still do, even after what you all have found him guilty of doing. There's something that's worth saving. You all get to decide what weight to assign to each mitigating factor that I'm about to go through with you. That's a decision for each of you to do. Each of you get to decide how much weight. We don't get to tell you that. We don't get to tell you that if you stack these up, there's no way they could overcome it. Only you can decide that. It's an individual decision that each of you have to make. Now, collectively, you all do need to find unanimously that each aggravating factor has been proven beyond a reasonable doubt. When it comes time to making that weighing, that's to you. That's to each of you. And the other thing I talked to you all about during jury selection, which is so critically important, was that individual decision and that individual moral assessment that each of you are going to make. We asked you all to treat each other with respect. We asked if you all would all agree to respect the decisions of your fellow jurors, and especially if they happen to disagree with your individual assessment. This is what we were talking about. That's the weight that we've put on you all. That's the job that you've been tasked with. So we're asking you to do that. We're asking you to look to each of those mitigating circumstances and weigh them against the aggravating factors that you find beyond a reasonable doubt. You heard from Mr. Quiles' family members and friends as well. You heard from a neighbor, someone who he worked on cars with, someone who he just happened upon. You heard him talk about the type of help he provided to him. Mr. Hale, Curtis Hale, gave you that information. You heard from a best friend of his aunt who was kind of like his mom. You heard the encouragement that he was to her during hard times. You heard from nieces. You've heard from cousins, nephews. You've heard from someone who was just like his mom, stepped in after his mom passed, became that aunt/mom, as she would describe. You heard her talk to you, and several of them talk to you about their love for Mr. Quiles. They've been here. They know the outcome. They know your verdict. And they were still willing to come here and testify to their support for a family member. To ask you to consider that when you're weighing these most important factors and circumstances. They asked you to save Mr. Quiles' life. Now, you're the trier of fact. We've been saying this from the beginning. You're the ones who get to decide, moving forward, what will be the recommendation. Let me talk to you about one last thing. We brought this up during jury selection as well. Actually, hold on one second. Let me grab something. All right. Just want to go through these mitigating factors a little bit more in detail, and then I'll wrap up with the last thing. One of the first mitigating circumstances that you're going to hear read from the court when you're read those instructions shortly will be that Mr. Quiles has no significant criminal history. Uncontroverted. No one has said that. That has not been disputed. That we have proven by a greater weight of the evidence. He doesn't have a criminal history outside of what you all have found him guilty of. He was 33 at the time of the crime. You've heard that he was raised by his mother. You've heard about his father being absent from his life and the effect that that had on him. You've heard about the loss of his mother and the effect that that had on him as well. You've heard about their special bond, their relationship, and how that bond has transferred over to his aunt. You've heard about from his aunt how she sees her sister through her nephew/son. You also heard about some of the challenges that he had. You heard about him using marijuana and alcohol and that being something that was normative, meaning maybe that's just the culture of the family and the effects that that has had on him as well. Dr. Rohrer talked to you a little bit about, very briefly, but she talked to you a little bit about him suffering some abuse growing up. You heard from his aunt about some conflictual relationships that he's had with his brother, and that being a very difficult relationship. You also heard about his education. He dropped out of school in the 7th grade, didn't complete the 7th grade. He's self-taught, but for the most part, that was it as far as schooling goes. And he did that because he became a father very young, at just 15 years old. 15 years old, he left school, started working. He's worked ever since, supports his kids. You heard that he has and has had a good relationship with those kids. He's got five children. 5 children that he still maintains a relationship with. You heard about the area that he grew up in. Even growing up in a high crime, poverty-stricken area in Brooklyn, New York, you still heard that he stayed out of trouble. He at one point went into a drug rehab facility to get away, according to him. Get away from what was going on around him. We also heard from Dr. Rohr about personality disorder, what that means for his relationships, what that means for him acting on impulse, doing things without thinking things through. He doesn't have any sort of severe mental illness. He's of average intelligence, which I would say is probably higher than what you would think of someone with that, with a less than a 7th grade education. He doesn't have any known neuropsychological issues or anything along those lines. Pretty average in general. No cognitive deficits or anything along those lines that you have to consider. But he did have a bit of a dysfunctional background, dysfunctional upbringing. Now, just to kind of go through, and I've gone through a lot of the other ones already, just to kind of go through that last thing, I talked to you guys about this during jury selection. If you can recall what I said to you, I told you all that you may get to this point. We talked about the process that you all have to go through. There has to be at least one aggravating factor. If you find one aggravating factor, then you move on to the next step. That next step, where we kind of do this weighing, and I'm skipping some of it, but you're going to do that weighing process. You found mitigating factors. I believe there are mitigating factors that have been proven by a greater weight of the evidence that you have. There's going to be aggravating factors that have been proven beyond a reasonable doubt. We're not disputing that by any means. When you go back and you do that weighing process, even if you find that those aggravating factors outweigh the mitigating circumstances that we've presented, that you've heard, that you've observed, that you believe, that you, in your individual assessment, determined to be true, even if then you find that those aggravating factors outweigh, life is still an option. You all still have the ability, even after all of that, to say life without the possibility of parole is the appropriate punishment here. And I'm sure you remember, we went through this painstakingly because I asked so many of you that question. I asked so many of you, if even after weighing, and even if you find that this is the worst case scenario, even if you find that those aggravating factors significantly outweigh, life is still an option. There's something redeemable here. There's something here that you can latch onto and say, life without the possibility of parole is what's appropriate in this circumstance. And that's what we're asking you to do. We're asking you to save his life. Does he deserve it? You probably don't think so. But is there something there worth saving? Is there something there that would make you all come back and say life without the possibility of parole is appropriate. It is a sufficient punishment. That's not letting somebody off. That's not letting accountability go by. That's holding someone accountable. That's making sure that this person does not have the possibility of ever doing anything like this again. So we would ask you today, as you go back, as you look at everything, when you come to that final decision within yourself of what is the right thing to do in this case, remember that life is still an option. And we ask that you would come back with that recommendation of life without the possibility of parole. Thank you.
Members of the jury, you've now heard all the evidence and the argument of the counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments. One, life imprisonment without the possibility of parole, or two, death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are as follows. Please note that the following aggravating factors apply to both counts 1 and 2 unless otherwise noted. 1. Johnathan Quiles was previously convicted of another capital felony or a felony involving the use of threat of violence to another person. First-degree murder is a capital felony. The crime of sexual battery is a felony involving the use or threat of violence to another person. 2. The first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. 3. The first-degree murder was especially heinous, atrocious, or cruel. This applies only to count 1. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to IS. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. 5. The unborn child of IS was a person less than 12 years of age. This applies only to count 2. 6. IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over IS. This applies to count 1. The unborn child of IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over the unborn child of IS. This applies to count 2. The state has the burden of proving an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, in conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided with a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility of parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must next determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. First, each of you must determine whether any mitigating circumstances exist. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are as follows. 1. Johnathan Quiles has no significant history of prior criminal activity. 2. Johnathan Quiles' age at the time of the crime. 3. Johnathan Quiles was raised by his mother while his father was absent from his life. 4. Johnathan Quiles was 33 years old at the time of the offense. 5. Johnathan Quiles began using marijuana at the age of 12. 6. Johnathan Quiles lived with his mother, but she was never present in his life and always worked. 7. Johnathan Quiles' mother's boyfriend abused him. 8. Johnathan Quiles was forced to drop out of school at a young age to take care of his child. 9. Johnathan Quiles went to drug rehab at the age of 15. 10. Johnathan Quiles began to work at age 15 to care for and contribute to his family and was unable to finish school. 11. There were no men in Mr. Quiles' mother's life on a regular basis. She had short relationships with men and her boyfriend abused him. 12. Johnathan Quiles' brother regularly bullied him. 13. Johnathan Quiles' mother is deceased and his only relatable family is his aunt and cousin. 14. Johnathan Quiles was raised by his mother in a high crime area. 15. Johnathan Quiles fathered a child at the age of 15 and had to work to provide for his child. 16. Johnathan Quiles had a poor relationship with his father and he was absent from his life. 17. Johnathan Quiles' father was absent from his life and his mother used corporal punishment. 18. Johnathan Quiles' IQ test is above average intelligence despite dropping out of school at a young age. 19. Johnathan Quiles does not have any known cognitive or neuropsychological deficits. 20. Johnathan Quiles has a history of alcohol and cannabis abuse. 21. Johnathan Quiles has a dysfunctional family background. 22. Johnathan Quiles has one brother. 23. Johnathan Quiles has a close relationship with his aunt and cousin. 24. Johnathan Quiles has a loving relationship with his 5 children. 25. After Johnathan Quiles dropped out of school, he had to take care of himself and his children. While his mother lent support, he had to take care of responsibilities causing him to leave the family home. 26. Johnathan Quiles was a hard and dedicated worker. 27. Johnathan Quiles has no disciplinary reports while in jail since his arrest. 28. Johnathan Quiles worked as a trustee in the jail. The final step in the process is for each of you to determine whether the defendant should be sentenced to life without the possibility of parole or death. In making your decision about whether the defendant should be sentenced to life without the possibility of parole or death, you must weigh the following factors. 1. Whether sufficient aggravating factors exist. And 2. Whether the proven aggravating factors outweigh the proven mitigating circumstances. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the results of each juror's individual weighing process, even if you conclude that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. If fewer than 8 jurors vote to the death penalty, your recommendation must be for life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. You will be provided with a form to reflect your decisions. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your decisions. When considering the aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. The case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your decisions should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. The verdict must be in writing, and for your convenience, the necessary forms have been prepared for you. They are as follows. There's 2 forms. Each form is 3 pages, one form for count 1, one form for count 3. It's slightly different than the last one you had last week, but all those very similar. The one I'm holding right now is one for count 1. As you can see at the top, it has the aggravating factors, and it goes through each aggravating factor for that count alleged by the state. And it says, we the jury unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to the defendant, Johnathan Quiles, in this case. And then you go down each aggravating factor and you check yes or no. That has to be a unanimous decision by all 12 of you on the jury panel. And remember, there's 5 per count, 6 total. If you check, and then on the next page, it tells you if you, the jury, answered no to every aggravating factor listed, you've completed your deliberations. The 4 persons should sign and date the form at the end of the form. If you, the jury, answered yes to any aggravating factor listed, then you go to section B, which is on page 3. And section B is on the last page. It goes through the instructions that you are supposed to go through, that weighing process that was talked about. And then at the very bottom, it tells you how to return your verdict in that regard. And then the 4-person signs and dates it. And it's the same process for count 2 as well. In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is choose a 4-person who will preside over your deliberations. The 4-person should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the 4-person's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about this case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through telephone, writing, electronic communication, blogging, Twitter, email, texting, etc. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, other devices here in the courtroom. The rules do not allow you to bring those phones or devices with you into the jury room. Mr. Gray will take custody of them just like last week, and you'll be given back to them at the conclusion of your deliberations or if we break for the day and come back tomorrow. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in that note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So, fortunately, we had all 16 of you for the past 11 days. Do the 4 alternates from last week, do you guys have any personal effects in the jury room? Okay, well, Mr. Gray will take you there to get your personal effects. I'll bring you back in here, and then I'll dismiss the other 12 to the jury room. So members of the panel, just like last week on Thursday, it's about 4:20. We'll be here until you guys tell us otherwise. If you guys want to break for the day and come back tomorrow morning, that's perfectly fine. Just let us know, and we'll bring you back tomorrow morning when you guys let us know you want to break for the day. If you guys want us to order you dinner by a certain point, let us know. We can certainly accommodate that as well. We need to know by 6 if that's your preference. If you don't want to break for the day and you want to go for a couple more hours, it's up to you. There is no rush. You take whatever time you guys need. We will wait to hear from you as to what you want us to do in that regard. We will be here as long as you want. And if you want to break or order dinner, we will do that. And if you want to break, we'll come back tomorrow morning and just continue your deliberations. It's up to you guys. You can let Mr. Gray know immediately, or you can wait a while and slip him a note. And we can go from there, and I'll let the attorneys know what your preference is in that regard as to how we move forward. But until then, all the evidence and the instructions will be provided to you in the jury room, and we will wait to hear back from you guys. You guys may have a seat. So to the 4 of you, this officially ends your jury service with us. You are officially dismissed. I'm sorry we had to bring you back, not knowing, you just never know what's going to happen with a member of the jury, so we wanted to make every effort. We brought this to conclusion this week. Even though you couldn't serve and be in the deliberation room, please don't think that your service is any less that we are less grateful for your service. It is to be here for 11 days is a monumental task. To be away from your family and friends, your work, personal lives, essentially put it on pause 2.5 weeks ago, is a monumental task. I am fully aware that when you got that summons in the mail about 2 months ago now, and when you came here that Monday morning, this is not what you thought your life would go for in September. I am extremely grateful for your service. We can't do our jobs in this courthouse without people like you willing to serve and step up. And I gave this what I thought was a profound speech a couple weeks ago regarding jury service and what it means. I am incredibly grateful for your service. But with that said, I'm sure you don't want to hear me talk anymore. You guys are officially dismissed. I feel like I know you guys already, but I don't know you at all. So you guys have a good day. Just so you guys know, the cameras never showed you guys. No one knows your identity. That's why I use juror numbers. That's my practice. And so just feel some solace in that. That said, you guys, security walk you guys out, and you guys are free to go. All All right, so the jury is officially outside our presence. I wanted to make a couple grammatical changes to the jury instructions. I read it as if the grammatical changes were fixed, but I want to give them a clean copy. So other than that, is there any exception or objection to the instructions as read to the jury from the state?
Your Honor.
Defense.
Judge, we raise our previous objections that we had stated before, having to do with aggravators and
The familiar or custodial issue?
yes, sir, Your Honor.
Okay. Anything else?
No, sir, Your Honor.
Okay, well, we'll be in recess. I'll fix this up. I'll sign them and get them off to the jury panel, and we'll just notify you guys when we hear something. So we'll be in recess. Let's go on the record. 19 CF 7518. I have counsel of state defense. Mr. Quiles present. My understanding is we have a verdict. Any reason why we can't bring the jury in? First from the state.
Not from the state, Your Honor.
Let's bring the jury in, please. Officer Fair, can you hold the jury real quick? I failed to say this before. If you don't believe you can contain your emotions one way or another, just please step outside, just as we did last week. With that said, Officer, you can bring in the jury.
Your Honor, the jury enters the court.
The verdicts are legally sufficient. I'm going to publish myself. Mr. Quiles, you may stand with your attorney. State of Florida versus Johnathan Quiles in 19 CF 7518, Division CRI, verdict as to sentence in count 1. We, the jury, find as follows as to the defendant, Johnathan Quiles, in this case. A, aggravating factors. We, the jury, unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to defendant Johnathan Quiles in this case. 1, Johnathan Quiles was previously convicted of a capital felony or a felony involving the use or threat of violence to another person. Answer, no. 2, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Answer, yes. Number 3, the first-degree murder was especially heinous, atrocious, or cruel. Answer, no. 4, first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Answer, yes. 5, IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over IS. Answer, yes. We, the jury, have unanimously found that the state has proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Johnathan Quiles should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Johnathan Quiles should be sentenced to life in prison without the possibility of parole. Signed and dated by the foreperson. As to count 2, we, the jury, find as follows as to the defendant, Johnathan Quiles, in this case. We, the jury, unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to the defendant, Johnathan Quiles, in this case. 1, Johnathan Quiles was previously convicted of a capital felony or felony involving the use or threat of violence to another person. Answer, no. Number 2, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Answer, yes. Number 3, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Answer, yes. The unborn child of IS was a person less than 12 years of age. Answer, yes. Number 5, the unborn child of IS was particularly vulnerable due to because Johnathan Quiles stood in a position of familial or custodial authority over the unborn child of IS? Answer, no. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Johnathan Quiles should be sentenced to life in prison without the possibility of parole or death. We, the jury, find Johnathan Quiles should be sentenced to life in prison without the possibility of parole. Signed and dated by the foreperson. Mr. Quiles, you may have a seat with your attorney. Does any side want the jury polled? Defense? Members of the jury, I have some final instructions for you. I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious or from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. On a personal note, I want to thank you for the past 2.5 weeks. We've been together for now 11 business days, and I am fully aware that when you received your summons in the mail 6 to 8 weeks ago, and then when you came here that Monday morning, this is not what you thought your month of September would go like. Far from it. Yet you showed up every single day to do good work. And I am extremely grateful for what you guys have done the past 2.5 weeks. It's not easy. It's difficult work. It's solemn. It's heavy. And I fully appreciate what you guys have been through the past couple weeks. I want you to know that there's a reason why I referred to you guys as juror numbers. It's a practice of mine, but there's been obviously a video camera here the entire time. You guys aren't captured in any of that. No one knows your identity outside myself and the attorneys. There's a reason for all that, which I'm sure you guys can understand and appreciate right now. But every day you guys showed up, and then your 4 other colleagues who didn't have the pleasure of going back in the jury room with you to deliberate. Every day you showed up, and not everywhere in the world can that occur. So I want to thank you for what you guys did the past couple weeks. And it's a lot to ask of people, but yet it's what our system of government demands of us. So on a personal note, I want to thank you very, very deeply for what you guys have done the past couple weeks. If you wish to follow the case at all, you can always contact my office. It's public record. And you can ask my assistant. She'll give you some information about it as well. But with that said, you guys are officially dismissed from jury service. And you guys can go about the rest of your week and the rest of your month as you deem appropriate, and with a deep gratitude for myself and from the attorneys. The jury is outside our presence. I still have counsel of the State Defense and Mr. Quiles present. What do you guys want me to do next?
Sorry, Judge. PSI potentially. And so at this point, I guess we would just request a sentencing date.
Anything from the state?
Nothing further to add. I know that if they want a PSI, obviously they have to do about 3 days.
And Judge, I know we talked about if there was even the possibility of waiving it or not. I know we didn't get into that today in discussion, but briefly talked to Mr. Quiles about that. We don't believe it's necessary, but it's not something that can be waived.
I think it can be waived. I think it's just because if it's a first felony conviction.
Correct, Judge.
I don't think there's any other requirement that he, in order to PSI's orders, given the jury's recommendation.
Okay, Judge, then I don't know if you want us to fill out a form with him, we're happy to do that, or however you want us to do that.
I'm not sure. If he does waive, are you guys intending to move forward with something today, or do you want a separate date nonetheless? What's the state's prerogative in that regard?
They would ask for a separate date so they can give it, other individuals can give victim impact statements.
Okay, well then you guys,
We have no objection to that whatsoever. We were going to ask for a separate date anyway.
what kind of date do you guys want? It would just be for a status date, and at that point I can inquire regarding him waiving the PSI, and we can pick a new date, a new sentencing date. I would prefer to do it sometime. I would prefer to have this case, if possible, concluded within the next couple weeks, if I can do that.
Your Honor, state is not having a status date on Wednesday or Thursday of this week.
Sorry, Judge, I was just checking Thursday. No, I'm not available tomorrow or Wednesday.
Thursday's a bit crazy for me. I can do Thursday afternoon. At that point, I'll know my schedule for next week and let you guys know.
Thursday around like 1:30, Judge, or what time were you thinking?
Yeah, I'll make it work. That's fine.
I'm just suggesting.
As I sit here, I'm not sure what my schedule's like the rest of the week. I've been somewhat busy with you guys, but I'll make it work. So 1:30 is fine with me on Thursday, just for a status, and if I could do the sentencing next week, given my schedule, I'll certainly do so. I'll throw this out there. I think I had an all-day hearing Friday. I think it got postponed as possibility if you guys are available. I don't know if you guys are. I know it's short notice.
I am not, Your Honor. I'm actually at 3.
Okay, so we'll pick a date on Thursday. We'll go from there. Is there anything else we need to handle from the state's perspective?
Not from the state's perspective, Your Honor.
Defense?
No, Your Honor.
All right, I know it's been a long couple weeks. I made a few comments in the past. Appreciate you guys, appreciate the attorneys, appreciate the staff. I know it's been a difficult case the past few weeks. I recognize that. I appreciate the professionalism from you guys, from the attorneys and from the staff, and how they handle things the past couple weeks. Everybody involved. Everything's been handled above board, and I certainly appreciate that. So I'll see you guys. What date is Thursday?
28th, Judge.
I'll see you the 28th at 1:30.
Thank you, Your Honor.
We'll be in recess.